disaster. You say I make you nervous, a tragedy, I'm a beautiful disaster, a reckoning. You wonder how I got this way. You think I'm someone to be saved, someone to clean up and tame. Oh, some things never change, never change. You think I would look pretty on your arm once you cover up my bruises and battle scars, but it always ends the same. Can't bear the things I've had to face, got you crying on your knees in pain. Oh, some things never change, never change. You'll break your back to make me feel again, suffocate to make me breathe again, lose your mind from endless pain. Some things never change, never change. Redemption never came. I stopped asking for forgiveness, cause you should know only fools tread where the angels fear to go, but you keep trying to get too close. Save myself by turning into stone, so save your judgment cause you just don't know. But some things never change, never change. They say I should feel guilty and change my ways, leaving crumpled bodies in my wake. Swear I didn't mean to make them break, swear I didn't mean to make them break. But they're so delicate and so mundane, and they keep coming like a moth to a flame. Oh, some things never change, never change. You'll break your back to make me feel again, suffocate to make me breathe again, lose your mind from endless pain. Some things never change, never change. Redemption never came. You say I make you nervous, a tragedy, I'm a beautiful disaster, a reckoning. You want
Good morning, I'm Jeff Bruce. We're starting up again in the state of Idaho. This is Kendy Howard. I spoke with counsel from Chambers on a number of issues. Mr. Counsel, you did want to make a record regarding one. Go ahead.
Thank you, Your Honor. It's a defense request to poll the jury after the 3-day weekend. Obviously, the media has covered extensively this alleged flight of Mr. Howard, who was following an individual who was there at the time of the arrest, returning a rental car. He was allowed to go to Spokane. He was not allowed to go within 2 miles of the airport. He had no bags in the car. He had his ankle monitor on. He had no tickets. He was not even in the airport itself. He was at the rental car exchange. Because of the media coverage and because of the assumption that it was flight, and because of the extensive amount of coverage, particularly locally here, the defense is concerned that it could taint the jury's view on the case, even though they're instructed not to. So this defense request to poll the jury.
Thank you. Responses?
Thank you, Your Honor. I don't think the jury should be polled, at least not yet. As the court knows, at least once a day, commonly more than once a day, that the court admonishes and directs the jury not to begin deliberations, not to discuss the case, and to basically not follow or seek information from the news or media outlets. And there, up until this point, including until now, that there's been no proof or indication or any reason for anybody to suspect that the jury has disregarded the court's orders. I think the court should be trusting of its orders. We live in a small world. The internet, social media, we're all connected, and there's been nothing from this jury to give anybody here any reason to suspect that they can't be fair and unbiased, even if they have seen something in the news. And so I don't see a reason to break from what's been a normal flow of the trial. Thank you.
Thank you. Well, I did speak with counsel in Chambers about this, and as I indicated in Chambers, I'm not inclined to poll the jury at this time. I have instructed this jury daily not to discuss this case with anyone else. I've instructed them specifically, particularly before the start of the weekend, to avoid news coverage, to not do any news coverage. And I trust that my instructions and orders to the jury are being followed. I believe just from my experience over the last couple of weeks, I think nearly every day there has been a news story or coverage of this case online, in newspapers, YouTube, on TV. So coverage, news media coverage has been extensive, which is why I advise this jury to avoid any news sources. And I trust they're following the court's instructions. This jury is a particularly attentive and conscientious jury. It was, I believe, the first day of trial or the second day of trial that we lost a juror, excluded a juror after having had some contact with one of the attorneys. And I think that impressed upon this jury the significance of following the court's rules. In fact, on a couple minor occasions, witnesses, once when a juror had some recognition of a witness, another when a juror had some business affiliation with a company that was referenced, brought that to bailiff's attention, addressed those issues with the jury. There was no concern. There was no inappropriate connection. But even in these minute, unrelated areas, the jurors brought it to the bailiff's attention, to bring it to court's attention. I say that because I just know this is a jury that has been very conscientious about following the court's orders and remaining impartial. And so I spoke with my bailiff this morning, indicated nobody has made any references to him or made any comments about anything. And I don't see a need to now hold the jury because there was coverage this weekend. I mean, there's been coverage last weekend as well of this trial. There's been extensive coverage of the trial, and I'm confident that the jury has followed the court's instructions and fulfilling their duties as they ought. So I'm not going to go into an old ones. But we did want to make a record, so Mr. Johnson, your record has been made and preserved. So thank you. Anything else before we bring in the jury?
Nothing official.
Okay, let's bring in the jury. Thank you. Be seated. Welcome back, members of the jury. I hope you had a good weekend. And we're back on record now for trial. Mr. Johnson, you may call your testimonies.
Chet Gilmore.
Chet Gilmore. Good morning, sir. Good morning. Please step forward and face my clerk and raise your right hand, please.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, you're welcome to have a seat there and witness stand. As best you can, please speak into the mic.
Yes, sir.
I'll let you begin. You may inquire, Mr. Johnson.
Thank you, John. Morning.
Good morning.
Can you please state your name and spell your name for the record?
My name is Chet Gilmore, Gilmore, Chet, Chet.
And where do you live?
I live in Spokane, Washington.
What do you do for work?
I'm a private investigator,
And how long have you been a private investigator?
about 10 years.
Can you briefly explain to the jury your training and background?
Well, I had a 25-year law enforcement career. That was in Spokane. So I did all of the normal learning to be a policeman training and spent about 14 years as a major crimes investigator. So myriad of various trainings to do with homicide, evidence collection, everything you can think of probably to do with a major crime investigation. And then, so after 25 years, then I retired from Spokane and became a private investigator. And during the course of that, I've done civil investigations, family investigations, but the majority of my work has been involved in criminal defense investigations, and really the whole gamut of types of criminal allegations.
Okay. Did you have an opportunity to participate in the investigation of Mr. Gilmore?
Of Mr. Howard, yes.
Oh, sorry, yes. Did you review discovery in this matter?
Yes, I did.
In general, what did that include?
Oh, it included much documentation, paperwork, officers' reports, evidence reports, a lot of photography, a lot of videography, both from officers, body-worn cameras, and purposeful cameras at the scene to document the scene.
Okay. Now, when dealing with photos, is there a way that you can look at properties of the photo and determine when those photos were taken?
Sure.
Can you explain?
Well, the photo has not just a visual photo of what you can see, but there's data or metadata that is embedded within the digital data of the file that you can open up and look at when it was last modified, but also when it was taken, when the photograph was taken, as long as that hasn't been stripped from the photo in some type of a transfer process or something.
Okay. Did you have an opportunity to look at photos taken by Deputy Wheeler?
Deputy Wheeler, yes.
Commissioner Potron?
Yeah.
In looking at did you have an opportunity to look at the data or metadata for the photos for Deputy Wheeler?
Yes.
Were you able to determine a range of when he took those photos?
Yes. I made some notes. Can I bring that out so I have the right time?
Would that assist you in your answering this question?
Yes.
You're on permission for Mr. Gilmore to review those?
If he needs to refer to those three questions, I'll read them.
Okay. And your specific question is?
What is the time frame that Deputy Wheeler took his photos while he was on scene?
What I made note of was the time that he took photos that included the bathtub area of the scene.
Okay.
And that time frame is February 2nd, 2021 at 11:24 p.m. until February.
I'm not objecting to reading from a document that hasn't been admitted into evidence.
Were those your notes you were looking at? Refresh your memory.
These are the notes that I wrote down when I was looking through the photos and checking the metadata on the various photographs.
Oh, so I'll ask you not to testify from your notes. So from
Okay.
your memory.
Sure.
Have you had a chance to refresh your memory on Deputy Wheeler's photos?
Yes.
And what was the range, time frame?
The beginning range was 11:24 p.m. past midnight to 12:29 a.m.
May I approach witness, Your Honor?
You may.
The motion was admitted as State's Exhibit 16G. Do you recognize that photo?
I do.
Is this one of the photos that was taken by Deputy Wheeler?
Yes.
And that would fall within that time frame?
Pardon me?
That would fall within that time frame?
Yes, it would.
Did you also have an opportunity to review photos taken by Detective Northrop?
Yes, I did.
Were you able to identify a time frame of when those photos were taken?
Yes, I was.
Do you remember what they are?
Yes.
And what were they?
It spread out over a longer period of time. The very beginning of those photographs that actually showed the bathroom tub area was at like 6:03 a.m. on the 3rd, February 3rd of 2021. Those were a little bit distant because they looked like they were from the doorway, so you didn't have much clarity. Once the photographer moved closer and started taking photographs, that was at 6:05 a.m. And then the officers appeared to be there for several hours, and there were a series of different times when the photographer would come back to the bathroom. And it's kind of hard to tell exactly where the break is from what's in the tub and when the decedent may have been removed from the tub. But the ending photographs all the way up until there was a body bag was in the afternoon. Looks like, excuse me, not afternoon, it was in the morning, 2.5 hours later, almost 3 hours later, 8:58 a.m.
Were you provided autopsy photos in this matter?
Yes.
How many autopsy photos were taken?
There were numerous autopsy photos, 200, a little over 200, I believe.
Did you have an opportunity to review photos taken at the morgue? Or after
At a later time?
Yes.
Yes, a few days later.
When were those taken?
Those were taken on the 5th of February.
Okay. Were you provided any information as it relates to Mr. Howard's phone?
Yes.
Did you have an opportunity to look at the call record as it relates to the morning of the 3rd?
Yes.
Permission to approach, Your Honor?
You may.
behind you what's been marked as Defense Exhibit I. Do you recognize that document?
Yes?
What is it?
This is a section of the CDR, the call data record, of the data extraction from Mr. Howard's phone, cell phone.
And is that an accurate copy?
Yes?
Move to admit Defense Exhibit I.
Any objection? No objection. Defense Exhibit I is admitted.
Who was the first phone call that Dan made on that exhibit?
On the 3rd? The time showing, well, the first phone call was made to Brooke.
Okay. Were there multiple calls made to Brooke on that day?
Yes.
And was there a call made to Wendy Wilkins?
Wilkins? Yes.
Does it appear that it was answered?
The Wilkins one just appears not to be answered by the length of time on the photo, on the call.
Permission to retrieve the
Okay,
contract?
sir.
Did you have an opportunity to examine any physical evidence in this matter?
Yes?
Can you explain how that came about?
Mr. Johnson made arrangements with the Sheriff's Department and Prosecutor's Office to have me and him go to the Sheriff's Department and look at evidence, various evidence that had been collected for the course of this investigation.
Did that evidence contain a vacuum bag?
Oh, yes, it did.
What was the state of the vacuum bag when you observed it?
Well, it was a whole bag, appeared to have contents within it, within another bag for preservation purposes of the contents.
Had the vacuum bag been opened prior to your observation?
No.
And then, did you have opportunity to look at any physical evidence as it relates to GSR?
Yes.
And can you explain?
One of the pieces of evidence that we observed was a gunshot residue, a GSR kit that had been collected from the decedent at the time of autopsy. The sample had been collected at the time of autopsy, and then the sample was tested for gunshot residue.
Okay. And what was the state of the, did you have another gunshot residue evidence in property?
No, that was the only test kit.
Okay. May I have permission to approach, Your Honor?
You bet.
And you, it's been marked as exhibit, Defense Exhibit H1 and 2. Do you recognize those photos?
Yes, I do.
And were you there when those photos were taken?
Yes, I was.
Is it a true copy of what you observed?
Yes.
Move to admit Defense Exhibit H1 and 2.
Any objection?
No objection.
Each one and two are admitted.
What is that the, when you say testing kit, is that the gunshot residue kit that came back from autopsy?
Yes.
Permission to retrieve the Your Honor?
You bet.
Thank you, Mr. Gilmore. I have no further questions.
Thank you. Any cross-examination?
Being a former police officer, you would know that the Washington State Crime Lab doesn't test for GSR, right?
I think they do on special requests, is my experience.
Would you be surprised if your answer was contradicted by another witness in this case earlier on?
Well, in my experience, which ended there about 10 years ago, there were times when they would do it if there was special requests for certain reasons. That's my recollection.
From 10 years ago?
Yes.
So you don't know if they still do that or not?
Correct.
And are you aware that most crime labs, state crime labs throughout the United States won't test GSR?
Yes.
And that's because it's not good science, right?
I believe there can be a lot of false positives.
And so it doesn't do much good, does it?
Oftentimes, it has its definite shortcomings.
Okay. Which why there was no point in this case in doing it, was there?
Objection calls for speculation.
Sustained.
You said there were about 200 autopsy photos.
Yes.
Are you sure about that? Did you overestimate that?
I can look at my notes and tell you what I wrote down.
Can you look at your notes and see if there were only 129 autopsy photos?
Yes, that's correct. I was counting a different set of photographs.
All right, so 129 autopsy photographs,
I have
not 200?
I have 129 photos.
All right. This vacuum bag that you saw in evidence, this didn't have any evidentiary value, did it?
Well, it was certainly collected to see if it had evidentiary value in it. Oftentimes, you collect things to see if there's anything that might support or negate assumptions or possibilities within an investigation. So
I
you
get
don't
that,
know.
but this bag didn't have anything of evidentiary value, did it?
Do you mean after it was looked at?
When you looked at it, it didn't have anything of evidentiary value, right?
By the end of the examination we did, yes. At the beginning, you don't know.
You were free to look at all the evidence in this case, right?
Yes,
You were free to read all the police reports, look at all the photographs, all the videos, right?
correct.
And assist in the defense of this case in various ways, right?
Correct.
And I assume that you spent many, many hours doing this?
Yes.
How many?
I don't know.
Don't you keep billing records?
I didn't keep billing records in this case because it was billed as a retained case with a certain fee for the entirety of the case.
You mean a flat fee?
Correct.
What was the flat fee?
Objection on all this.
Goes to bias?
What is the answer? Overruled.
$10,000.
Does that include your time here testifying today?
It includes it.
Did you retire from Spokane?
Yes.
No further questions.
Thank you. Any regret?
Yes, sir. So counsel asked you about evidentiary value. Was anything found in the vacuum bag other than hair and dirt?
No.
No glass?
No, that was one of the things we were specifically examining for, to see if there was anything like broken glass that would speak towards one of the what appeared to be proffered within the police investigations as a possibility of evidence.
So the absence of glass could have evidentiary value. Is that true?
Objection, lady.
Sustained.
Is there any evidentiary value in the absence of glass?
Yes.
And what would that be?
It would show that
I'm going to object. I think this calls for speculation.
No, he was a major crimes detective. I think he's qualified to answer.
I'll allow him to answer as to what his perception of the evidentiary value will be.
given that there was some glass fragments that were collected by law enforcement at the scene, and there was at least my presumption was a vacuuming is done to see if there is more glass fragments to show that there's been a cleanup attempt by somebody, cleanup of potential evidence, that type of thing. And so in that examination of the vacuum bag, there wasn't any evidence that we could find sifting through it that there was broken glass in there. So I guess that would negate that one, that particular assumption or speculation.
Counsel asked you about your flat fee in this matter. When did you start working on this case?
I started working on the case shortly after the incident occurred in February of 2021.
So for 3 years you've been working on this case?
Objection.
Sustained. Sleep.
How many years have you been working on this case?
3 years.
Okay. And was your flat fee $10,000?
And I need to make a correction. When I first started on the case, there was an hourly fee. And I believe for that first section of investigation, I think it was $1,600 maybe, I believe. And then you approached me for a flat fee for just the remainder of everything that might need to be done during the course of investigation, and that was the $10,000.
No further questions, sir.
Thank you, sir.
Thank you, sir.
Also have a couple minutes. Of course.
Before the next witness, there's a couple things I need to address with counsel. And so we're going to take a short recess. You might not discuss in case of yourself or anyone else. Please stand up. You can be seated. We spoke in chambers earlier, and we're trying to capture it, but other parties make their motions too. Mr. Johnson's next witness is the defense expert witness who created a detailed report that was provided to state to provide the court as part of the motions. In that, he had a number of photos and scenarios that the defense outlined. And then, as I understand, and counsel can correct me if I'm wrong, but the state today, this morning or last night, this morning was provided with new photographs as well as a couple new animations that the expert had just provided to defense and was intending to present. And so the state was objecting to that, asking for exclusion because they weren't aware of these and weren't ready to meet them on cross or and the defense was arguing that these were essentially, I think, Mr. Johnson, you're saying that you thought it was consistent with the report, but ultimately, I indicated I thought it was too late to spring that on the state this morning. I indicated the witness was still welcome to. These are animations of a person's arm in the position of Ms. Howard, as the defense would put it. I indicated the witness is certainly welcome to show the jury whatever he wants in his own movements. And, he can testify from the stand. I asked you providing these animations and photos. It was too late. It's prejudicial, and I didn't think it was appropriate to allow that. Mr. Berger, I don't know if I've accurately stated the state's
You have to.
objection. Mr. Johnson, I don't know if I've accurately stated your response, if there's anything you want to comment.
No, Your Honor, I just need a few moments to go. I have maybe questions. I just need to go. We can see it, make sure.
You say no, Your Honor. Have I accurately stated your objection?
Yes, sir.
Okay. But there's nothing further you want to put on the record?
No.
Got it. Okay. Did you need just a minute?
Just a couple minutes, just for the statement.
Listen, does anybody need like a cotton break or anything, or just a couple minutes? Sure, Judge. Why don't we take 5?
All rise.
Mr. Johnson, you were able to make appropriate reactions?
Yes, sir.
Okay. All right, we'll bring him in. Sorry, I had everybody sit down. Go ahead and stand. You can see it. Mr. Johnson, you're playing this with us.
Jeffrey Desmond.
That's Morning, sir.
Morning.
Can you please step forward and face my clerk and raise your right hand, please, for me?
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can see that, please. As best you can, if you would speak to the mic.
Will do, thank you. Is that good?
You may depart.
Thank you, Your Honor. Good morning.
Morning.
Doctor, can you please give us your name?
Jeffrey Thor Damelin, last name spelled Desmoulin.
And how do you spell Jeffrey?
Geoffrey.
Where do you live?
Vancouver, Canada.
Doctor, what do you do for work?
I am a professional engineer, and most of our work involves litigation support through forensic engineering. We also teach. In fact, I'm supposed to be at ILETA this week, which is the International Law Enforcement Educators and Trainers Association, teaching a course on biomechanics from video.
Okay. Can you tell the jury a little bit about your educational background?
Sure. I have 4 degrees. The first one being in kinesiology, which is the study of human movement. So you're going to see a lot of that today. I specialized in biomechanics in that degree, but also had several undergraduate courses in anatomy and physiology. I went on to do a master's degree also in kinesiology, specializing in biomechanics, but as part of that degree, took courses in neurophysiology, and then went on to do a second master's degree at Wayne State University in Michigan, specializing in injury biomechanics, so the tolerance of the body and how engineering parameters are used to predict injury. And then finally ended up with a degree in mechanical engineering at the University of Calgary, also specializing in tissue injury and repair.
Have you had any publications?
Yes, I publish regularly, both in scientific forum and non-scientific forum. I think we're above 40 for scientific forum now, and likewise, similarly for non-scientific forum, i.e. magazines, etc.
Okay. Permission to approach, Your Honor?
Right.
Thank you.
Doctor, I've handed you what's been marked as Defense Exhibit J. Do you recognize that?
I do.
And what do you recognize that to be?
I recognize it to be my current CV.
Your Honor, move to admit Defense Exhibit J.
Any objection?
None, Judge.
Defense Exhibit J is admitted.
Permission to approach, Your Honor?
You may.
Doctor, can you briefly explain what biomechanical engineering is and what it entails?
Sure. It's the understanding of mechanical principles applied to a biological system, and in this case, humans.
Okay. Have you had an opportunity to review this case with your biomechanical engineering perspective?
Yes, sir.
Permission to approach, Your Honor?
Okay.
Doctor, I'm going to show you a series of photos. Just let me know if you recognize these. This is Defense Exhibit K1. Do you recognize this?
I do.
K2. Do you recognize this?
I do.
K3. Do you recognize this?
I do.
K4.
Yes, sir.
K5.
Yes, sir.
K6.
Yes.
And K6, for the record, has been redacted. Do you see that?
I understand.
And K7.
I understand, but I also understand that the figure on the left is in the report.
Okay. All right, and so K7 has also been redacted.
Okay.
And K8, do you recognize this?
I do.
And for the record, this has also been redacted.
Okay.
K9, you recognize this?
I do.
And this has been redacted.
Okay.
K10, same thing. Do you recognize this?
I do.
Redaction. K11, do you recognize this?
Yes, the results of one of our simulations.
Okay, and this has not been redacted.
Okay.
K12, you recognize this?
I do.
K13, do you recognize this?
As a summary of our results, yeah, it's biomechanical results.
K14, do you recognize this?
As a separate test of blood pooling, yes.
And then K15, do you recognize this?
I do. That's a video that we provided with the report.
Are these portions of what went onto a PowerPoint?
Yes, sir.
And do you recognize what's marked as K17?
Yes,
And is that your initials on it?
it is.
Would referring to this information with the redaction was noted, but would this assist you in your testimony today?
I think it'll assist the jury in understanding what we've done, yes.
Okay. Your Honor, move for admission for demonstrative purposes only, K1 through 15 and K17.
Any objection?
Judge, may I confer with counsel for a moment? No objection.
K1 through 15 and K17 will be admitted as demonstrative exhibits. Sir, I don't know if you'll be able to see from where you see it. So if you need to step out into the well, you're welcome to do so.
Thank you, sir.
And permission to approach.
Okay.
Dr. Contessa, I don't know how it'll show up on screen. Here's a pointer.
Thank you.
Now, what is the investigatory process?
Okay, so the purpose of this investigation was to see if biomechanics could rule out suicide. That was the goal, eliminate the possibility of suicide. And so what you're seeing here in this first process floor, the investigative process, is a published process in which to approach an investigation such as this. It was published by myself and a former professor of mine, Dr. Theodore Milner, in scientific forum. It's also been published several times in non-scientific forum, and it's dictated the process in which I followed to come to our conclusions. And so if we start with defined injuries, you'll see that it says from autopsy report, and that would be Dr. Howard's autopsy report with his cause of death, and relying on that. Moving forward, we're talking about defined dynamics. This wasn't captured by video. We do have witness statements from police officers as to her final resting place. We also have many scene photographs over several time periods, and we relied on that, especially her final resting place, as we'll get into in a minute. The analysis was based primarily on biomechanical modeling, as you'll see, but also a multitude of published literature and a full incident reconstruction of the event. We moved on to discuss how using these results were consistent with independent information, and then made our conclusion.
Okay. In your analysis of defined dynamics, were you able to observe any information from faro scans?
Yes, sir.
And can you explain what a faro scan is and how you relied on that faro scan?
Sure. A ferroscan is a distance measurement machine on steroids, if you think of it that way. It's collecting many points per second, and it does that in 3 dimensions, and it gives you a 3-dimensional representation of a scene that is accurate in dimensions. So we were able to understand the dimensions of the tub itself, and then use that together with a biomechanical analysis of the known height and weight of Kendy.
Okay. And did your analysis in this case involve research?
I'd say there was a literature search that would assist, that would be helpful for you to understand. There was research on biomechanical modeling and an incident reconstruction of the event.
Did your research inform you as to any significance of intraoral gunshot wounds?
Yes, there was a paper, Schmidt, or Kendar 2022 actually, that analyzed intraoral gunshot wounds and found that the trend was most of them were suicide.
Did you have an opportunity to review trajectory in this case?
I relied on Dr. Howard's interpretation of the trajectory. We also found photos from the autopsy useful in interpreting this, and also Dr. Nara's description of the trajectory was also helpful in the sense that it was horizontal to slightly downwards.
Okay. And did you examine the position of the body?
Yes, that was detailed carefully because we're working backwards from this moment in time with our biomechanical analysis. Specifically, we focused on the position of the arm, the orientation of the arm. What I mean by the orientation is hand up or hand down, and also the position and location, or I should say the position and orientation of the gun itself. So right-hand side of the body and the barrel pointing towards her head. That became important in our analysis.
Okay. What is what did you look at as far as it relates to the firearm?
Well, we started there because that's the initial input to the hand as a system, as a mechanical system. And so we needed to know or understand the overall weight of the gun, where that weight is centered on that gun, the effect of its overall momentum. So we have a bullet that is published as being 90 grain in weight, moving at 1,040 feet per second. That gives us a momentum that occurs over 1 millisecond, and that gets the mechanical system moving, if you will. We also considered the slide movement and what effect that might have, either on the teeth or the hand itself, if it's being held with two hands. And then, of course, the trigger weight became very important. And what I mean by trigger weight is the amount of force you have to apply the trigger to actually discharge that firearm.
How did that become important to you?
Because there's lots of strength studies on index finger strength as well as thumb strength, and it changes depending on wrist angle. So ergonomically, there's a very specific way that you'd have to hold that firearm in order to match that trajectory and pull the trigger at the same time. What these studies are showing is that any wrist angle over 20 degrees is too much to be able to press 5 pounds with your index finger. And most of the positions were greater than that. In fact, they were closer to 60 degrees wrist flexion. And that actually allowed us to rule out the use of the index finger to discharge this weapon.
Hey, we'll come to this again, I'm sure, but
Sure.
you mentioned most of the positions. Can you describe what you're referring to there?
Sure. There was many considerations. One was the use of the left arm, but if that were the case, the gun would have ended up on the left-hand side of the body, so we were able to quite easily rule that out. Again, the goal being to eliminate the possibility of suicide. Because the gun was found on the right-hand side, we focused on right hand and both hand scenarios. From there, we considered Kendy's stature with respect to the bathtub and what would be a natural position for her to be sitting there in. One is a sitting position and one is a reclining position, and then various positions from there, as you'll see in our results section.
Doctor, what is ergonomics?
It's the study of how humans interact with their environment. Specifically here, we're looking at strength requirements to perform a task. This task being depressing that trigger at least by 5 pounds. We are forced, that position is dictated by the trajectory and the positions and ranges of those joints. As I mentioned earlier, Lee 2002 found that any wrist postures flexion greater than 20 degrees was impossible. It was not possible to depress with your index finger a 5-pound trigger, so we were able to rule that out. However, in Imran 1991, looking at various pinch tasks, which is really measuring thumb strength, we were able to see that in various wrist positions, we would have enough force there to depress that trigger above 5 degrees. And so the focus became ruling out index finger positions and starting to focus on thumb trigger pull positions.
Now, what if the index finger is strong enough? Did you look at that?
Then it would actually increase the number of scenarios that would be consistent with suicide.
Okay. Did you examine the effect of recoil?
Yes, sir.
And can you kind of explain that?
Sure. So as I mentioned before, the transfer momentum from the gun to the hand applies a force to that hand. And the line of action of that hand, the line of action of that transfer momentum is along the barrel. That's what the assumption was. And it lies just above the hand itself. And so in that position then, the only thing that can happen with the wrist is supination. That's what this motion is here. And you can even just try it yourself by pushing on your first knuckle there. You'll cause an opening of your hand. And that became important to rule out many scenarios.
Okay. Did you have a chance to look at flexation? And, well, let me back up. What is joint axes and how did you test them?
Right. I think what this slide is getting at is the axes that were tested. So, for example, we limited it because the majority of the interaction with Kendy's arm after the discharge of the firearm would be gravity. We limited the axis of the shoulder into flexion extension, so in line with gravity. Did the exact same thing with the forearm, but the wrist we considered pronation, supination in isolation, i.e. it would be controlled by the input from the revolver, and then we also considered wrist flexion extension in our model. So those were the axes that we considered to move from a starting position to her final resting position.
Do you have any, how many scenarios did you examine?
We considered many, but we simulated 10.
Okay. And on that, when you say simulated, can you walk through what you mean by you simulated scenarios?
This is a mathematical model. It's not a graphic artist's rendition of what they believe to have occurred. This is physics driven, and so what you're seeing here, this is one of our scenarios results, and this is a situation where we had Kendy reclined and holding the firearm with two hands. And so what you're seeing here, the green line, is in fact the gun hand complex. Okay? And you can see it slightly flexes, slightly extends as it moves throughout the motion. The first blue line represents the forearm, and the second blue line represents the upper arm. And it's important to note that the gun shape there is giving you the consequence of that model. So where does the barrel point when it gets to the bathtub floor? And is that associated with any supination? As I said before, so you can think of supination as holding some soup in your hand. It's open. In this case, that supination torque was actually canceled because we've considered both hands being on the firearm at the same time, and therefore the hand remains in a neutral position as it falls to the bathtub floor. But this would be a very typical simulation result, and we'll get into what those results mean in a table in just a moment, and what we've considered with each of them.
Did you look at or review any marks on Kendy's hands?
Yes. There was a linear laceration to her left hand, and in some cases, when you're not always aware of exactly where your fingers are in three-dimensional space and you discharge a firearm, you get what's called slide bite. And so this linear cut could have been caused by slide bite.
Objection, lack of foundation calls for speculation.
Okay. Did this also serve to rule out other possibilities, Ms. Mark?
Again, the idea was to eliminate suicide as a possibility, and so we used this slide bite mark as a way to do that. So if we did away with the slide bite mark as being a possibility, then we'd actually add to the number of scenarios that would be consistent with suicide.
Okay. Now, did you put your, you said you considered many, but you modeled 10 scenarios?
Yes, sir.
And did you put that in any sort of visual representation?
The results we did.
Does this explain that?
It does.
And feel free to move about and explain to the
I was
jury.
going to say, I think this would be a good time to do that. So just starting on the left-hand side here, what I'd like to explain is we started with overall gross body posture of Kendy's final position, and we considered both a sitting and a reclined version of that. Okay, so that's an arm mean.
And Doctor, real quick, just so you know, that is a touchscreen, so.
Oh, I'm sorry. I'm bad at touchscreens. I'm not a guy, but anyways, gun orientation. So this is the gun orientation at time of discharge. Okay, so we considered a vertical position as well as a horizontal position of the firearm. When I went to the hand, as I said earlier, we eliminated the left hand being involved because that would have caused the gun to be located on the left-hand side of the body. That's pretty clear in the evidence that it didn't happen, so we did not consider it. We did consider the both-hand scenario, as I motioned to before. The trigger finger, we considered index finger as well as thumb discharge. And then how did these scenarios align with the evidence? So if we can just go through these one at a time. So here we have sitting, vertical, gun orientation, right hand index finger. We were able to eliminate this primarily based on trigger pull force, but also because it's single-handed, we would not have seen the slide out. And so you can see every condition in which we consider the index finger has been eliminated based on that ergonomic data that I showed you earlier. Just going down one row, we see sitting posture, vertical gun orientation, right hand, and thumb. And that is consistent with everything that we see documented at the scene, except for the slide bite. So as I mentioned earlier, if we get rid of the slide bite, we actually add scenarios that are consistent with suicide. So that's the approach here. And so if we look at trigger pull force, you can see we eliminated based on index force strength, based on arm position, or arm, upper arm that is, landed on the right-hand side in the same position in all cases. The arm orientation, interestingly, in the sitting condition, there was enough time, even though we had that supination occur at the discharge of the firearm, there was enough time that after her arm interacted with her thigh to settle into a more neutral position as found at the scene. Also interestingly, in the reclined position, there was very little time for the hand that was now supinated to make its way back into a neutral position after the elbow had touched the bottom of the tub. So in the reclining position, the elbow hit the bottom of the tub first, and then there was very little time for the forearm to correct itself, if you will. However, in the condition where both hands, where both hands are held on the gun, that doesn't actually happen, because when that firearm is discharged, it cancels the supination torque, keeping the right hand in a neutral position, allowing it to fall into the neutral position found at the scene.
Okay. So, in this also, did you talk to us about what you found as far as evidence on blood on the face?
Sure. So what you're seeing here is photographic evidence from the scene. This is a completely separate question that I was asked. And the question was, if blood had pooled into matted hair, could it cause a skin stain that appeared to, in an upward movement, to quote unquote, move against gravity, if you will. And so these were the two photographs that we were working with. The first one being at the time of Officer Wheeler's photographs, and the second one about 7 to 8 hours later when the coroner arrived. And you can see that there's some water that has been draining over that time period.
When you're looking at that line, did you, would head movement after death impact that?
There's many factors that would affect this. One of them is, I think head movement can't be ruled out as being a possible cause of this.
Okay. And such as if someone were to check for a pulse, head movement there?
Correct.
Objection to leading.
Also state, if you could rephrase your question.
What's an example of something that could cause head movement?
Checking for a pulse.
Now, can you give us, did you do any experimentation with blood?
We did.
Can you explain that a little bit?
Sure. So to test that question, or to answer that question, if hair is matted against the cheek and there's bleeding into that hair, could it cause a skin stain that has an upward curvature to it? What we did is we took sheep blood, ordered from the government, which is the forensic standard, to do that. You warm it to 37 degrees Celsius so it maintains appropriate fluid flow, etc. And we used human hair against pigskin to test this result. And if you go to the video, you'll see a summary of exactly what.
Well, let me ask you about that.
Sure.
In your testing, did you model it with video? Or not model it, did you capture a video of your test?
Yes.
Okay. And is this depicted here?
Right, so we're calling this blood accumulation on skin in a water basin test. Here's the injection shown with time lapse, 12 times the speed it actually occurred. So there's the bleeding from the mouth into matted hair on the skin. It's a little choppy, but you get the idea. I think what's important here is the settling of the blood in the bottom of the basin.
So the blood didn't taint the whole water?
Objection to leading.
Sustained.
And what I mean by settling, the blood
Objection,
settling.
there's no witness. No questions.
Okay.
That's right.
Also sustained.
Can you, let me go back here, can you walk us through, let's just back up this first experiment, or first portion of the video. What are you showing on this first portion of the video?
This is just the like how we simulated bleeding into matted hair on the skin.
What happened to the blood in your testing?
It settled at the bottom of the basin.
Okay. And when it changes, can you describe what we're looking at?
So here's the ejection of the blood, simulating bleeding from the corner of the mouth into matted hair. Here you're seeing the draining over time, that 7 to 8 hour period between the photographs. And then a reveal once the hair is removed as to what the skin stain actually looks like.
Okay. Now, after your analysis, did you reach an opinion?
I did.
And what was that?
The opinion is that there was one scenario that would be consistent with suicide.
Would that scenario increase if you rule out the possible slide bite on the left hand?
It would.
And in that case, how many scenarios?
2.
Thank you, doctor. No further questions, Your Honor.
Thank you. Cross-examination.
Thank you, Judge. I noticed that you put a lot of emphasis on looking at all the evidence when you're making a decision or a conclusion about a case. Is that accurate?
I'd say we focused on what was biomechanically relevant.
Well, when you were speaking with counsel, you said the goal was to eliminate the possibility of suicide, right?
Correct.
And is that how you viewed this case?
Yes, sir.
All right. And so in order to determine that, it became very important for you to look at all of the evidence, right?
Correct.
Specifically the evidence of autopsy,
Correct.
the evidence at the scene.
Yes, sir.
Those things will be very important when you're deciding whether or not this was really a suicide, right?
Depending if it's subjective or anecdotal, yes.
Okay. May I approach, Judge?
Yeah.
let me publish for you 19B. This came into evidence a little bit earlier in this case. And I'm going to ask you some questions about it in terms of your opinion about suicide, okay?
We're going to object it's been outside the scope as it relates to a diagram put together related to bruising that was not the subject of his direct examination or the biomechanical analysis.
He's testified he relied on the photographs of the autopsy in this case, and that's simply what this is, Judge.
Mr. Chair, I apologize. I think I just stepped up from there. Seated. Counsel, I guess I want to understand, well, I mean, this seems beyond the scope, but I want to understand what you're, I want to give you the chance to give you a little bit more, but it sounds like you're, it's I recall 19B, it's the various bruising on the body and so forth, and you wanted to ask this witness about that?
I did, Judge. This witness has already said that he's relied on the autopsy photographs. He's already opined about an autopsy photograph that had what he called a slide bite on it. To simply ask him about these other autopsy photographs at this point would be relevant, and it would be especially relevant as it pertains to his idea that he's trying to rule out a suicide. I think it goes directly to the heart of that testimony, Judge. If you have someone who has multiple injuries throughout their body, who has a second-degree burn on their arm, who has a broken jaw, who has signs of suffocation, whether or not there was a suicide in this case is directly on point. And so I think I should be allowed to go there.
Mr. Johnson?
Thank you, Your Honor. He was asked to look at the body position, gun position from a biomechanical engineering standpoint. Whether or not he was to look at or provide an opinion of marks that show up 2 days after the traumatic autopsy where they do so much stuff, there's lividity. That's a separate, he has not testified to that, it's beyond scope. This was solely focused on the biomechanical and the interaction of the blood and the water. We know the state's opinion on 19B, but that's not fact. And I think it's beyond scope, and I think it's improper.
In the court's view, this witness hasn't testified that Ms. Howard committed suicide. This witness has merely testified to biomechanics that would make it possible in the scenario of how to hold a gun or not hold a gun. And a brief comment on the demonstration on blood in the bathtub. This would be very different in the court's view if this witness did opine that Ms. Howard committed suicide, or the evidence, the autopsy and so forth was consistent with her committing suicide and so forth. But this, in the court's view, this expert has limited his testimony solely to the biomechanics of what's possible biomechanically or engineering-wise in terms of how a gun can be held and so forth. So I think this is beyond scope and not proper. I guess the one thing I can see allowing a question simply to the extent that there were multiple other injuries that you didn't consider as part of your biomechanical review. But to show the witness additional autopsy photos and get his opinion on whether or not this was suicide or homicide, I think is significantly beyond the scope of this witness's testimony, and frankly outside the purview of his expertise. So let me grant the objection in limited, as I just indicated. Let's bring the jury. You can be seated. Sustained objection. Mr. Hearn, you may continue.
Thank you, Judge. Sir, if you eliminated the possibility of Kendy being alive when she was shot, wouldn't you eliminate the possibility of suicide?
If I had evidence to show that, that would be true.
That would pretty much do it, wouldn't it?
If I had evidence to show that, yes.
All right. And so in terms of evidence, I assume your attorney that you work for gave you all the evidence in this case. Is that correct?
Yes, sir.
Because you wouldn't have come to the conclusion that you had otherwise, right?
I'm not sure what you're referring to, but I considered everything I received.
All right. And so you considered the prior testimony and additional report of Dr. Ryan Rambiran, right?
Correct.
And his conclusion was that she was dead when she was shot. Do you remember that?
I do.
And you know that Dr. Rambiran has a medical degree?
Yes, sir.
Many years of experience as a trauma surgeon? Yes?
Objection.
Yes.
Let's go. Sustained.
You considered the report of Dr. Smock?
Yes, sir.
Dr. Smock was very clear that she was dead when she was shot, right?
Objection, not that scope.
Sustained based on my ruling previously.
Why, when you had these other pieces of evidence, this medical evidence, wouldn't you discount the possibility of suicide from the onset?
None of them actually were at the autopsy. I had an autopsy report from an equally qualified individual telling me that the cause of death was gunshot wound intraorally. And that's how I moved forward. A lot of the evidence that I had considered from those individuals I felt was primarily anecdotal.
Even though they had training and experience far in excess of yours?
In the medical area,
Right.
agreed, except there are many things that don't fit. For example, the amount of blood that was present. There was, I think, 2 individuals that testified in grand jury that there wasn't enough blood for this to have occurred when she's alive. But in fact, there's many factors that would prove that. I didn't say they prove it wrong, but I could prove it wrong in the sense that first of all, nobody's accounted for the amount of blood that was actually present, as far as I know. Number 2, we saw that the blood, via test, which you don't need to be a doctor to assess, sunk to the bottom of the bathtub. Number 3, you've got blood that was lost during the draining between the hours when Wheeler took his initial photographs and the coroner took his initial photographs. Further to that, Schmidt, 1994, documented a very similar case where there was a witness suicide, an intraoral gunshot wound that perforated the tongue and ended up in the upper cervical region, very similar to what we see here. And there was no aspiration of blood. There was very little blood found at the scene. And the conclusion of that paper, which was not by me, anyone can read that, was that there's a possible mechanism of reflex arrest when the spinal cord is involved. And so it stops the heart very quickly. And so taking all of that information in consideration, I think it casts doubt on that opinion.
On medical opinions? And you're,
Yes, I can do that.
You're qualified to make that assessment?
Testing doesn't lie, as you saw. Those were my findings.
In your report you wrote on page 32, last part of the first paragraph, last sentence, furthermore, neither Mr. Livingston nor Dr. Rambiran offers an explanation as to where the missing blood might be found or how it disappeared. Do you remember that?
I do.
Okay. And you were provided with the transcript from the grand jury, right?
Portions of it.
And so you had that when you made that statement, right?
That's correct.
Let me show you that grand jury transcript of Dr. Rambiran. Direct your attention to page 559, line 23. And wasn't Dr. Rambiran asked the question, quote, okay, and so again, you know, the question remains, had the heart been pumping when this bullet went through the tongue, what would have been the result? And then what's his answer there on line 2, page 560?
It says, again, significant and profound blood loss.
Why don't you take a moment, sir, and go through the rest of that particular page on that transcript and tell me whether or not Dr. Rambiran does explain where the blood would have gone. Had she been alive when she was shot?
He's testifying the fact that there would be in the order of half a liter to a liter of blood loss from that type of wound, which is inconsistent with the research that I cited, but I understand that's also a possibility.
So he talked about on line 22, page 560, the blood could only go 3 places, into the lungs, into the stomach, and into the environment, right?
Correct.
And then he talked about, on the next page, 561, about there being no blood in the lungs or the stomach, right?
Similar to the case study I quoted.
So
Yes,
it
sir.
had to go into the environment, right?
No, sir.
That's what he testified to, right?
That's what he's testifying to. I've shown you.
You told us in your report he gave no explanation. I'm attempting to show you that he did give an explanation, okay?
He says into the environment, but we don't ever see that, is what I meant by that statement.
And because you drew the conclusion, because there is very little in the environment, that she was dead when she was shot, right?
Except we still don't know where the missing blood is.
Do you agree that his conclusion was that she was dead when she was shot?
That was his conclusion, correct.
And so when you wrote that he gave no conclusion in your report, that was incorrect, wasn't it?
I think you're mischaracterizing what I said.
Didn't you say, furthermore, neither Mr. Livingston nor Dr. Rambiran offers an explanation as to where the missing blood might be found or how it disappeared?
Right.
And isn't
That
his
she was-
explanation that she was dead when she was shot?
except it still doesn't account for where that blood actually is,
It would be in her body, sir, would it not?
except there's blood in the water.
Yeah, there's very little blood in the water, isn't there?
Nobody knows that.
Don't you think a medical doctor can make such an assessment?
I think a test is worth 1,000 expert opinions.
Don't you think a medical doctor has extensive training in terms of determining how the heart works?
Of course, I'm not judging that. I'm just going by the literature I cited.
Okay. You wrote on that same paragraph a little bit further up, given that gunshot injury involved transection of the spinal cord at the C2 level, it would have cut off brainstem regulation of the respiratory and cardiovascular systems. Remember that?
I do.
And is that accurate by your account?
It's also yes, and it's also consistent with the research that I cited. I speak specifically to the regulation of the heart rate. So blood pressure can go up, blood pressure can go down, or the other option that was given by the research I cited was that it can also stop the heart.
Are you familiar with the medical concept that the heart runs on a different nervous system than the lungs?
Yes, it can continue beating.
All right, and so that bullet transection at C2 wouldn't necessarily stop her heart, would it?
Not necessarily, no.
Okay, so her heart could have kept pumping, right?
That's true.
And so your statement's not correct, right?
No, you're mischaracterizing what I'm saying.
You said it would cut off brainstem regulation of the respiratory and cardiovascular systems, right?
Regulation, so sympathetic, parasympathetic, things of that nature. But I would defer to Dr. Howard's autopsy opinion about that. I would also defer to the research that I've cited.
Okay, so her heart would have kept pumping had she sustained that bullet wound. Is that what you're saying?
Not necessarily, no. And I've shown how that is possible.
Because of that study?
Correct.
Do you remember what that study was? What the name of it was?
It was Schmidt, 1994, case study number 3.
Let me approach it. I think I have the right study. All right? Take a look at it. Tell me if you recognize it.
Sure. I recognize it.
Is that the
I'm
one?
referring to.
That's the one you're talking about?
Yes, sir.
And in this case, what you're focusing on is the person that shot himself.
That was witnessed and had no aspiration into the lungs similar to this, and there's a little blood found in the scene. And the authors on page 59 conclude there was no doubt that contusion of the cervical spinal cord can cause reflex heart arrest. And that's what I'm specifically referring to.
All right. Now, what I wanted to ask you about with that particular study, I'll find one in here. Let me pull this up. All right, there we go. Recognize that?
I do.
That's your K3? Your exhibit K3?
Yes, sir.
What is it?
It's just a rendition of Dr. Howard's description of the wound path.
Okay, and what's your description of the path?
Perforated the tongue, ended up fracturing C2 and transecting the spinal cord at that same level.
So to transect the C2, is it going down or up?
It was described as being horizontal or slightly down by Dr. Nara.
Well, I'm asking for your opinion as you sit there and look at that line today. Is that going horizontally or is it going down?
Clearly it's going down.
Okay. And so you would describe the trajectory of the bullet that went through Kendy's mouth as downward?
I didn't analyze the trajectory, but we're, referring to Dr. Howard's report, that's,
Do you think you could analyze that for us and tell us what your conclusion is in terms of the trajectory?
it's perforating the tongue and transecting near C2.
Is it going down or not, sir?
Of course it's going down. Yes, sir.
All right. Where's the soft palate?
Soft palate is upper region here,
Can you show us?
right there.
All right. And so the study that you relied on with the person that shot themselves in front of a witness, didn't they shoot themselves through the soft palate?
It was intraorally, and it was upper cervical region is where the bullet ended up. Similar to this, it did transect the tongue, but I agree with you that there was some differences.
So this one study that you've relied on, there was a completely different trajectory, wasn't
It
there?
wasn't completely different. It was intraoral, it transected the tongue, and the bullet ended up in the upper cervical region, similar to this case.
It was different in that bullet went up, whereas the bullet in our case went down, right?
It wasn't described that way.
Okay. If you read the journal entry, if you read the facts, you know that the bullet went through the tongue and into the soft palate, right?
I believe that's what it said, yes.
One can make a pretty good inference that shot is going up if it's going into the soft palate, as you've just showed us, correct?
There's different regions of the soft palate, though. I mean, the main one is here, but also back here before it turns into the pharynx.
So you can't agree that this other study, the trajectory was going up?
It's not detailed to that level, so I can't know.
Wouldn't that make a difference if it was going up, in your mind?
It still details that it was upper cervical region, so we're looking at more horizontal, possibly slightly upward trajectory in this particular case file, yes.
In that study, it didn't even go through the C2, did it?
It says upper cervical region.
So you don't even know where the bullet landed in this other study, right?
It's upper cervical region, is what they say.
And I guess what you're doing is you're basing this conclusion that her heart would have stopped based on a study that isn't really applicable to our case, right?
I disagree with that statement.
Okay, even though we have these differences?
There's slight differences.
Okay. In that particular study, I think you still have it in front of you, on page 57, it indicated a very low percentage rate of handgun injuries that involve the neck region. What was it, 2% there under discussion, number 3? Is that right? According to this study that you referenced.
You're referring to the sentence that says only a few suicides shoot themselves in the neck?
Actually, I was going to get to that one next. I was looking at about 2% of handgun injuries involve the neck region. It's a little bit above that.
Or do you see that?
Do you agree with that?
That's what they say, but I'm assuming that's external.
Okay. Well, what about that next line there? Only a few suicides shoot themselves in the neck. 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction, while the vast majority, as in cases 1 and 2, are homicidal. You agree with that?
I'm not sure what line you're on.
Go down about 5 lines. So we're still under discussion on page 57. It starts off, as you noted earlier, only a few suicides shoot themselves in the neck.
I see. And then it continues saying 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction. Except I believe in that case they're talking about external gunshots to the neck, not intraoral.
What's the last part of the sentence?
Well, the vast majority, as in cases 1 and 2, are homicidal.
You agree with that?
That's what they state.
Well, you relied on the study for another fact, right?
What's that?
That her heart could have stopped based on that shot.
You mentioned that there's a reflex mechanism for that, yes.
Yeah. So I'm asking you if you are good with this as well.
I would be, yes.
Okay. You relied on another study. I think, I'm sorry about that. Autopsy features relevant for discrimination between suicidal and homicidal gunshot injuries.
Is that Carter 2022? Sure. Yeah, that's Carter.
I think he quoted some parts of that article. Is that accurate?
I didn't cite them as accurate. I mean, if they're published, the scientific community has accepted it. What I was drawing some attention to is the trend of intraoral gunshot deaths are primarily suicide.
Okay. What I wanted to ask you about is on the first page under abstract. It's kind of near the end on the left side. And quote, it says, from 61 suicides who fired the gun inside their mouth, only 1 pointed the gun downwards. Consequently, some bullet path directions cannot be considered indicative of suicide. Downwards and back to front in gunshots to the temple, left to right in gunshots to the left chest, and downwards in mouth shots. You remember reading that?
Yes.
When you cited to this article in your report?
That's also in our report.
Do you agree with it?
I can't deny it, no.
Okay.
I believe the statistic was 95% are homicide and 5% are suicide. So you still can't rule it out is the point.
Okay. And in our point here, when you've got a downward trajectory in terms of the gunshot wound to Kendy, it's indicative of homicide, is it not?
According to that literature, it is.
That you cited to.
Correct.
Take a look at page 276. under direction of the bullet path, it says, quote, "The direction of the internal bullet path may differ between suicides and homicides for a particular entrance wound site. Suicides commonly intend to have a stable and comfortable position of the shooting hand in a fatal effect of the gunshot." Remember reading that?
I don't actually, but you've refreshed my memory.
Do you agree with it?
If that's what they're saying, can we just go to that part one more time? I didn't get a chance to read along with you.
You want me to read it again?
I'd like to read it myself.
Oh, take your time.
Okay. And it's 276?
Yeah, it's under direction of the bullet path. You want me to point it out to you?
Oh, there it is. I see it. So you've read the first paragraph? Is that what you're referring to?
Not the whole paragraph, just the
Okay.
first couple of sentences.
Yeah, those are the trends, yes.
All right. And so that last part is what I kind of wanted to focus on. For someone to get a comfortable spot in order to shoot themselves, you agree with that assessment in that particular article you cited to?
Typically, things are done ergonomically, yes.
All right. All right, let me show you some photographs, I think. You probably got some of them in for your returning. Real quick. Recognize 100?
I do.
What do you recognize that to be?
The two conditions of the firearm at discharge that we considered, so horizontal being A and vertical being B.
101?
That's horizontal. It's one of the positions we considered.
102?
Another position we considered.
And then the last one, 103?
Yes.
Same thing?
Yes, sir.
All right. Those are accurate photographs or images from your report?
Yes, sir.
Move to that 100 to 103.
Any objection?
For demonstrative only.
I'll do them as demonstrative.
Okay, so looking at 100 here of one of your images, one of the problems I think you told us about with this not being able to be consistent with Kendy shooting herself is it the angle of the wrist? Is that accurate?
Correct. We found that in that wrist position, according to strength tables, she would be unable to depress the trigger.
There's another problem with either of those two examples too, isn't there? A big problem.
What's that?
Trajectory.
And these are demonstratives. It's just showing index finger versus index finger, yeah, in the two positions. But it's important to understand that this is based on Blender model, and that is a characterization or representation, not the actual angles that were used.
The trajectory doesn't work here, does it?
Sorry?
The trajectory does not work here with these images, does it?
With these images, they could be made to work, but these were probably performed early on when we were putting the report together. But I assure you, there's lots of other examples where the trajectory is correct and considering these positions. But I've already stated that the index finger is not a condition that would work in this particular case.
Right, nor with this trajectory.
Correct.
Okay. And then looking at 101, does that get you to the necessary trajectory in our case?
It would be close. Appears to be close, yes.
But that doesn't really look like a comfortable way in which someone would shoot themselves, does it?
Agreed.
It's a little odd, isn't it?
It is, but it was a consideration.
It's not really how she was positioned in the bathtub either, right?
Not a final resting point, no.
And so that just isn't accurate at all, is it?
I disagree. I think this is a possible scenario. The tub itself is modeled accurately, placed the feet and the buttocks close to where they were found at rest, and then obviously if this was a position, she would settle into the reclining position she was found in. That was the idea.
Kind of the same thing, but you've reclined her as opposed to the previous photograph here in 102?
Correct.
All right, do you think that gets us to the necessary trajectory?
It's close.
It's still got a little bit of a problem with being comfortable, right?
Agreed.
Okay. And then I think what you ultimately thought was your best method of showing that Kendy shot herself was 103. Is that accurate?
That's the scenario in which both hands are being held, and yes, that's the most likely scenario, the ones we've tested.
How long is that slide on the gun? I think you put it in your report. It was like a little over 5 inches, right?
Something like that, yes.
How long is her hand? You got that in your report too, right?
I don't recall.
Let me track that down. Hold on. Turn to page 37 of your report. Let me know when you get there.
I don't have a copy of my report, so
No.
I copy.
Yeah.
Spokane there.
All right. And do you see where you've got the hand measurement?
I do.
And you put the hand as 0.063, right?
I did.
And that's in meters.
Correct.
Can you convert that to inches for us?
That would be approximately 2.5 inches.
And that would be the length of her hand.
No, sir. That is the center of mass of a coiled hand.
You've got under hand, under body segment, you've got hand, right?
Yep,
And then under length, you've got that figure, 0.063, right?
I do.
So how long would her hand be?
We modeled it as a closed fist.
Would her hand be as long as the slide of that gun?
It could be.
Okay. Doesn't that seem like an extra long hand?
Not at all.
What about that thumb?
I was about to answer.
Oh, I'm sorry, go ahead.
It's okay. It depends where you're placing the thumb. And the thumb is helping support the pistol grip in this particular scenario. And so when the slide moves backwards, the knuckle or the thumb itself is actually very close to the slide.
Okay. That thumb appears unusually long, right?
No, it's just an effective blunder.
Why does it have that skewing to the left there at the end following the knuckle?
Just a representation of the position. I could demonstrate it for you if you'd like.
Well, I'm just curious why you had the thumb in this awkward position going like this and then down. Do you miss that?
I think there's other ways you could hold this. This is one that would be consistent with that injury.
All right. Were you attempting to make this work with that laceration on her thumb?
Not at all. This pistol is not ergonomically designed to commit suicide. And so there's going to be an awkward position in order to hold it.
So this article that we started off on this tangent here about suicide and people that do it being comfortable doesn't really apply to Kendy? Is that what you're saying?
All I was referring to is that humans in general will find ergonomic ways to do things. It lowers the amount of energy you have to expend, you less contraction of muscle, you're working within the mid-range of the optimal ranges of your joints, et cetera, et cetera. Obviously, if you're motivated to do something that would force you to use additional range of those motions, of your strength capabilities, the joint range of motions, you're going to choose to do that. That's all I'm getting at there.
Let me publish 20Y for you. And you remember what that is?
That's the linear abrasion we're referring to. Yeah, one of the photographs of it anyways.
Okay. What about 20W? What's that?
I believe that's the same linear abrasion.
Doesn't Kendy have two of them?
She may.
You don't know, do you?
This is what I was specifically referring to in the slide bite.
Did you know that Kendy had two cuts on her thumb?
They didn't appear to me to be in the same place. There is an explanation for it in the sense that this would be the one that would be most likely to have occurred. The other one would also be possible if both sides of the thumb interacted with the slide.
So, you do know that she had two different cuts on her thumb, or you don't know that?
It appeared to me that they were in different places, yes, but I couldn't confirm that they were or not.
So one was a slide bite and one wasn't. Is that what your assessment of that is?
No, I'm just saying that injury is consistent with a slide bite. It's also consistent with other types of injuries.
Okay. Have you treated slide bite before?
I don't.
You don't see patients?
Excuse me, I was talking. I don't see that as an injury that needs to be treated.
All right. You've never treated slide bite before, right?
I don't think any of the slide bite references that I've seen, I don't think would require anything other than minor first aid.
Overruling the objection.
So are you saying that doctors don't treat slide bite?
Not at all. It would just be minor first aid.
Do you think a doctor would be more familiar with slide bite than you?
I think there was an example of slide bite in Dr. Smock's report, but that's a completely different position and also dealing with soft tissue rather than tissue that's overlying bones.
So are you referring to 22C when you're talking about slide bite?
Correct. That's abrasions and lacerations over soft tissue in a very different position of the hand
And
rather than
22,
over the knuckle.
and 22B?
Correct.
Okay. And so you would agree with Dr. Smock that that is slide bite?
That's slide bite when somebody's using the firearm ergonomically and doesn't place their hand appropriately, although I know experienced firearm shooters that this occurs regularly in.
How much have you made from this case
Objection, Your Honor. Liquor license allowed. Overruled.
so far?
I believe the amount is in the 40,000s.
Okay. Was that for the report?
I think the majority of that is yes.
Okay. And then for today?
For today was complicated. I had other commitments at council. There was a non-refundable retainer fee for that to change that scheduling conflict. And obviously I was paid for my time while being here.
So how much total?
It might be north of 50.
No further questions.
Thank you. Redirect, Mr. Duffy.
Yes.
What did you have to cancel, Doctor?
I was scheduled to teach at the ILETA conference, which is the International Law Enforcement Educators and Trainers Association.
Now, you mentioned in answering some of the questions about Blender. Can you explain what Blender is?
Sure. Blender is a very nice way to visualize humans in a 3D space, as we did in this particular case. It's been used to characterize anatomy. It's been used for forensic reconstructions. It's also used for animation studies as well.
From a graphical standpoint, is Blender what you conduct your modeling in?
No, sir. It was just to visually represent the thought patterns. It's the stick figures that were the mathematical models.
Okay. So it's the differences in the visualization, would that change your opinion from your modeling?
No, sir.
Okay, and why is that?
Because the modeling is physics-based, whereas Blender is a representation of that.
Okay. Now, remember at the beginning when counsel started asking you, him asking you about Dr. Rembrandt?
About the amount of blood present or not present?
Yes.
Yes.
In your review, did it appear that Dr. Rembrandt accounted for any blood loss down the drain?
Overruled.
May I answer?
Yes.
I did state earlier that there was an amount of blood that would have been lost. We saw quite clearly in the video that blood collected near the bottom of the tub, and that there was at least an inch of water that had drained out over the time period between the two photographs. So how much blood was lost, I don't know, and I don't think any other expert can tell you that, or at least haven't addressed it.
Did it appear that whether or not Dr. Rembrandt accounted for the blood lost in the body bag?
I don't recall testimony to that regard, no.
Okay. Are you aware of any, in your review of the autopsy and the materials provided, are you aware of any other injuries that would cause bleeding other than from the tongue and the damage caused by the gunshot?
Major bleeding, not that I noticed, no.
Okay. Now, you stated earlier that testing is worth 1,000 opinions. Do you remember making that statement?
I was quoting a gentleman who was, one test is worth 1,000 expert opinions, in my
Okay.
opinion as well.
And as your opinion, can you explain that?
What I mean is that, and we can see this at work in this file, there's many well-qualified people with differences of opinions and focuses on various aspects of the evidence presented. However, with one test, I think it's very clear that you would be able to understand as a jury that blood now sinks in water, and that is a visual and an example of that phenomenon that is undisputable.
I have no further questions.
Thank you, sir. You may sit down.
Thank you. Should I leave these here or take them with me?
Sure, this is it.
I'll clean them up.
Okay. Thank you. Councilman Brooks. be seated.
Let me have just a moment, Your Honor.
You may.
Riggs.
And Mr. Johnson, I understand that was your last witness outside of your client, is that correct?
Yes, Your Honor.
And is it your understanding of whether or not Mr. Howard intends to testify?
Your Honor, I discussed this with Mr. Howard. He understands it's his decision. Under advice of counsel on his decision, he will be not testifying.
And Mr. Howard, I'm going to ask you some questions, okay? Do you remember that you have a constitutional right to remain silent during the trial?
Yes.
Do you understand that because the state has the burden of proof, the law does not require you to testify in order to win your case?
Correct. Yes.
Do you understand that if you do testify, you will be subject to cross-examination by the prosecutor?
Yes.
Do you understand that if you do not testify, the prosecutor cannot mention this to the jury or suggest that failing to testify is an indication of guilt?
Yes.
Have you made a decision as to whether you will testify at your trial?
Yes, sir.
What is your decision?
I'm not going to testify.
Is your decision not to testify based upon consultation with your attorney?
Yes.
Do you understand that your decision to testify or not testify is solely your decision and your decision alone?
Ultimately, yes, Your Honor.
And it is your decision not to testify?
Yes, Your Honor.
Have you had sufficient time to discuss this matter with your attorney, including the pros and cons of testifying or not testifying?
Yes, Your Honor.
Has anyone used any force or pressure on you in making you arrive at that decision?
No, Your Honor.
Have you made the decision not to testify freely and voluntarily?
Yes, Your Honor.
All right, the court hereby finds and concludes that the defendant has made a knowing, intelligent, and voluntary decision to exercise his Fifth Amendment right to remain silent. All right, then what we'll do moving forward, we'll bring the jury back in. I'll have the defense. I'll give you the opportunity to rest. I know the state has an opportunity for rebuttal. Is it correct, Mr. Hearing? After
1:30.
detail this afternoon?
1:30, Judge.
At 1:30, okay. All right, so then I'll let the jury know that we're going to let them have a longer lunch than normal today, and we'll go from there. Okay, we'll bring the jury. You may be seated. Mr. Johnson, any further witnesses from the defense?
Your Honor, the defense rests.
Thank you. All right, members of the jury, the defense having rested, the state is allowed the opportunity to present rebuttal. They do have rebuttal lined up at 1:30, is my understanding. We moved a little faster this morning. So I'm going to give you a longer, we did 2-hour lunch today while I address some other matters with counsel. I anticipate, well, I should say what I anticipate. I don't want to give anybody false hope, but we're moving along well. There's a chance the case will get to you even today. That's what I was going to say, but I don't want to promise that. I'm just telling you we're moving along well. So I'll give you a longer lunch than normal. Look forward to seeing you back at 1:30. Remind you not to discuss the case among yourselves or with anyone else. Thank you. All rise for the jury, please. You may be seated. All right, counsel, before we break, there is an issue with the state's motion, which I haven't received. Mr. Johnson, I'll trust that you have a copy of you via email probably, that you haven't seen yet.
Yeah, I haven't seen it.
But I'd like counsel to be back at 1 o'clock, ready to argue that motion. That would work for everybody. Because, Mr. Johnson, I know that's moving quickly, but it should give you time to review the motion. Will that work for the state?
Certainly. Would the board be inclined to take up the issue of the jury instruction conference during lunch hour?
Yes, I just want to make sure Mr. Johnson has enough time. Do you want to meet at? Sure. Why don't we talk about it? Why don't we meet with council chambers real quickly and let's sort that out. Okay. All right. We'll be in recess. Thank you.
All right.
If council wants to just come changes and stuff. consciousness of guilt, there must be other circumstances present and unexplained, which together with the departure reasonably justified an inference, but it was done with a consciousness of guilt, and in an effort to avoid apprehension or prosecution based on that guilt. In these circumstances, I'm struggling with the initial finding, even of flight. Mr. Howard clearly violated his conditions of release. He was ordered not to go to the airport, or go within 2 miles of the airport, and he violated that. But it's unclear to the court that there's flight or departure. He's been allowed to go to Spokane. While it could be said he went out of state, in reality he's less than 45 minutes away from the courthouse, and he's back and forth there all the time. His attorney's office is there. He's not restricted from going there, and it's just unclear to the court that I actually have flight. Mr. Howard this case has been pending for years, and Mr. Howard has turned himself in, has been present at court at all times. And without diving too deep into the nitty-gritty of what exactly he was doing, I don't know what exactly he was doing, but it certainly seems probable to accept that his friend had flown in here to testify for him, and he had turned in his car rental that night and was doing so. The facts, again, this is just offered proof that seem to support that that's what Mr. Howard was doing. Now, the things that go counter to that, as the state's mentioned, the counter-surveillance maneuver, the evasive maneuver, so to speak, on the highway, the fact that there's a gun present in his car, Mr. McCullough claims that was his. Those cause the court pause and some concern. But, and I do think mitigating that somewhat is the fact that he still was wearing an ankle monitor. There was no secret where he was. And again, in the court's view, this would be a vastly different situation if he cut the ankle monitor. This would be a vastly different situation if he had an airline ticket in hand, if he had a bag packed and cash, and the court sold his passport, so I know he doesn't have a passport, but if he had a flight, a ticket in hand, cash, and packed, and ready to go, those would be circumstances that, together with the departure to Spokane, could justify the inference of his own consciousness of guilt. I'm having trouble finding those initial findings, and I recognize that if the evidence is there, it's ultimately for the jury to weigh it. But before it gets to the jury, I need to be satisfied that there was a flight or a departure, and it's just not clear to me that there was. There's certainly, I think, an equally strong inference that he was making his friend drop off the car rental and coming back. Now, I do find it hard to believe that he forgot his restriction at the airport. I find it hard to believe. And I do think it's concerning enough that when I received a phone call late that night to address this, I issued a warrant, respond to be revoked. I am ordering that his release continues to be revoked and he'll be held up on for violating the court's very clear order. But in terms of allowing the state to reopen and present this evidence to the jury, I think it's very. I don't think it's strong. I don't think there's strong evidence here, and even with just needing to justify an inference, I'm not sure there's an inference here that what he did was done with a consciousness of guilt, and that it was an effort to avoid apprehension or prosecution. And given that, then under the weighing it under Rule 403, I find the probative value of what he did, meaning that's the legal term, the probative value, the strength of the evidence for proving something, I think is relatively low. I think the prejudice outweighs the probative value. Frankly, I don't know that the prejudice is tremendous either, though, because the defense could explain all this, apparently. But nonetheless, I think the probative value is outweighed by the prejudicial effect of this evidence. And so I'm going to deny the motion to reopen the evidence and to present this evidence to the jury. All right, with that, though, we will turn to the state's rebuttal case, and I anticipate us adjourning for some time to get your instructions ready for the jury and the parties will return for closing arguments, and we'll move forward to deliberations.
Your Honor, just a clarification. Earlier this morning in chambers, you indicated that after you ruled on this motion, you'd reconsider whether or not to pull the jury.
That's correct. Thank you. I did indicate that earlier. I explained I wasn't going to pull the jury. I did say in chambers one of the reasons I wasn't going to pull the jury as well is that if we presented the evidence, the jury is no point in polling them because they would have heard the evidence. So since I'm not allowing this to be presented to the jury, the issue of polling the jury is back before the court, as Mr. Johnson has requested. I still am not going to pull the jury. I still feel strongly that this jury has been attentive and conscientious and is following the court's orders and rules, and I don't see the need to pull regarding this one issue of media coverage. So I'm going to still deny to pull the jury. Okay, stay ready to proceed.
Just as soon as we get Dr. Smock on I assume, Judge. Should take a minute or two.
Yeah, let's just take a short recess and then just let you know when we've got it. And we'll be ready.
Thank you.
Thank you.
All right.
Mr. Johnson, I'll have you just, or counsel, I'll just have you put on the record that party stipulated to the Zoom appearance. Okay, let's bring in the jury. Be seated. Thank you. Welcome back to the jury. And we will continue at this time. The defense is resting. The state has the opportunity for presenting rebuttal testimony, Mr. Bernard.
Thank you, Judge, and we intend to do so via Dr. Smock and Zoom, and I understand from counsel that there's no objection to that.
That's correct.
And I
Okay,
think,
you may proceed.
I think we have Dr. Smock on Zoom at this point.
Dr. Smock, if you're able to hear me, you're welcome to turn on your video. And when he was there about 30 seconds ago. Are we on mute? Dr. Smock, this is Judge Baris. If you're able to hear me, you're welcome to turn on your video.
Thank you, Your Honor.
Thank you, sir. You may inquire, Mr. Verheeren.
Thank you, Judge. Would you like the doctor sworn in again since it's a new day, Judge?
Yes, thank you. Dr. Smock, if you would please raise your right hand where you are. Be sworn in by my clerk.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Dr. Smock, for being available today. Where are you right now?
I am at my home in New Albany, Indiana.
We heard from Dr. Howard. Dr. Howard told us his conclusion as to cause of death was gunshot wound. Do you agree with that or not agree with that?
No, sir, I do not agree with that.
And do we have some photographs that have been previously admitted that can help you describe why you don't agree with that? All right, let's start off with those. I think the first one's 17K. We are all looking at 17K. Doctor, can you see it as well?
Yes, sir, I can.
Doctor, can you describe how 17K is consistent with your opinion that she did not die of a gunshot wound?
Yes, sir. There's several things that, and I don't know, can you see my mouse? I don't know whether my mouse is moving, probably not.
Nope.
No, can't see. Okay, I'll do my best to describe it to the jury. But when we look at the front of Ms. Howard, there's several things that tell us that she sustained other injuries other than a gunshot wound, and she sustained injuries pre-mortem, meaning before she died. So let's look at the two. First, let's look at the lip. The left lip, and you can see the bruising that goes down from her lip, down her chin, down into her neck. So remember that in order to bruise, your heart has to be beating. So that's number one. And number two, there's an injury to the front of her neck. There is bruising to this area right here in the front, which Dr. Howard didn't even mention in his autopsy report. It was clearly visible in these photos. So in order to bruise, you have to be alive. Your heart has to be beating. And I think as we go through some of these other photos, so clearly Ms. Howard sustained a gunshot wound. But my opinion is she sustained that gunshot wound post-mortem, after she was dead. And I think if we work through these photos, I'll be able to begin to explain to the jury why that is what happened to Ms. Howard.
Okay. Can we go to the next one, please? And what we're looking at is 20C. Can you tell us how this supports your theory or your belief, Doctor?
Yes, sir. Well, let's look at, she has injuries on the left and the right. And what is underneath that injury on her lip? Well, on the inside, she has a laceration, a tear, where her lip pushed into her bottom teeth. That bruising is on the outside of her lip. Meaning, if you look inside the lip, it's between the lip and on the inside of the lip. So why is that important? Well, let's look at Dr. Howard's opinion that this fracture occurred from something related to the gun. Well, I can tell you it didn't happen from the slide of the girl for two reasons. One, the bruising is on the outside and on the inside of the lip, not on the inside of the gun. And her teeth are not broken. When I've seen injuries from a slide, meaning the top of a semi-automatic handgun, going back into the teeth are broken. And her teeth, both upper and lower, are pristine, which says this injury did not occur from the slide of the gun. Looking at the far side of her, on the right side, which is away from that fracture and the bruising on the left side, she has some damage, injury to that lower lip. That is what is consistent with some trauma pushing her lip into her teeth. And that is consistent with suffocation, pressure being applied to her nose and mouth.
And not a gunshot wound?
Not a gunshot wound. No, it's on the opposite side. If you start looking, remember, I tried to explain before that I take every injury and analyze every injury to determine does it fit or not fit with any particular history or the facts of the case. And when I see injuries on two sides of the lip, that doesn't support, for several reasons, that it's associated with a gunshot wound at all. But number two, we have those two locations, and we have injury to the left side of her nose as well. So three separate locations on the nose and mouth that are unrelated to the gunshot.
I think our next slide is the inside of her mouth.
I think this is a better picture from the front of her mouth, showing on her nose, the left side of her nose, she's got a bruise over there, and the bruise comes from blunt force trauma, something causing the blood vessels to rupture. We've got the mark on the right lower lip, and what's interesting about that is that length of that mark is consistent with the length of one of her teeth, being pushed into her teeth from the outside, not from the inside coming out, but from the outside coming in, and then the extensive bruising over the area, over the line fracture of her jaw.
Show us the next one. Looking at 20G, Doctor, what can you tell us about this that refutes what Dr. Howard said?
This is, I don't think we can zoom in on that lip itself. I don't know if the PowerPoint can zoom in or not. If not, but looking at the inside of the mouth, the inside of the lip, look where the laceration is. In fact, it's on the inside. And then look at all the bruising that is on that part of the jaw, or the skin that overlies that part of the jaw. That's where the bruising is, not from the inside, where something could come from the inside out. And certainly that happens, but that is not what we have in this case. And so the injury we see here is from some sort of external trauma. And I believe there was a blunt force trauma to her jaw that pushed her lip into her teeth, and then that same force fractured the jaw directly underneath that part of the lip.
Can you go to the next slide, please?
Oh,
That helps?
that close-up that I was hoping you could see. We look at that laceration in the tear of the skin, and where is it? That's on the inside of the lip. And the characteristics, you see how it's a line going across? That's similar to what we see on the other side. So that's the type of injury you expect to see and do see when tissue is pushed into the lip or into the teeth from the outside.
One of the things that Dr. Howard said was that the blood that was visible in Kendy's mouth, tongue, and neck issues was essentially consistent with an intraoral gunshot where someone was alive when the gunshot was made. Do you think that that is correct?
No, sir, I do not.
Why not?
Well, look at the photos of the tongue. We know that the heart will continue to beat for a certain period of time after a bullet goes into C2. So where is that blood? Yep. Kendy, who were alive when the gunshot went in and through her tongue and then down into her spinal cord, we would expect way more blood. And why is that? Well, when we asked with Dr. Nara, dissected the tongue, you saw all the arteries and the veins that were torn apart, ripped apart. Arteries bleed like stink. They will pump. And so what you would expect to see, if Ms. Howard were alive when you would expect to see blood coming out of her mouth, spurting from all those arteries. And is there any evidence of any sort of spurting coming from her tongue? Zero. There is nothing that says blood spurt from her mouth, from the arteries, which is what you expect to see. Remember, it can only go 3 places. Her lungs, no blood in her lungs. Stomach, no blood in her stomach. So it would go out of her mouth. Is there any physical evidence, any forensic evidence that says there's spurting from arterial bleeding coming out of her mouth? No. It's basically it's dripping out of her mouth. It's not spurt. There's zero evidence of spurt.
And looking at that slide there, would that be the normal amount of blood for a person to displace in a tub like that had she been alive when she was shot?
No. Everyone knows, men and women, that when we even get 1 or 2 drops of blood from our rectum or from our vagina, whether there's menstrual blood from women or hemorrhoids from men or anybody, you know that 1 or 2 just drops of blood will turn the whole toilet bowl red. And you can see through this blood. This is basically, you've got red blood cells dispersed in the blood, or in the water of the bathtub. But had the injury occurred and she was spurting blood or arterial or even venous blood flow into this while the heart is pumping, it would be way different. There would be so much more blood, you would expect it to be, you couldn't see through it.
Okay.
So the blood seen in this photo, in that water bathtub, is not consistent with a living person being shot.
Okay, thank you. Next slide, please. Okay, so Dr. Howard called that skin slippage. Do you agree with that?
There is skin slippage because there were blisters on the skin, but the skin slippage is from a 2nd-degree burn. And what's very interesting about looking at this pattern, when you are exposed to a liquid and you have a burn, it's based upon, the severity of the burn is based on 2 things. One, the temperature of the medium, water, oil, whatever it happens to be, and the duration of contact. And, I'm sorry, you can't see my, but I'll try to explain this. You can't see my cursor. But is there, just look at this photo. Is there a difference in the color of the burn that's closest to the wrist versus the one that's down closer to the elbow? And to me, the one further toward the wrist is lighter, and the one closer to the elbow is darker. So what explains that? What physiologically explains a difference in the characters of the burn? Well, think about when water or any liquid goes onto a surface, and here it's the right arm. As that water drips down, there is longer contact with that water with the skin because it's dripping down. So the longer you have the contact, the deeper the burn. And look at the difference between the color of the burn at the top and the color of the burn at the bottom. Is there a difference? Yes. The color of the burn at the bottom is darker, which indicates a deeper burn, which goes along with liquid running down the arm, staying in contact with the skin longer, creating a little deeper burn. This is not skin sloughage from being in the water too long. Now, where you start to see sloughage is on the fingers. This is not from being immersed in the water for a couple of hours. That just doesn't make sense. I would not agree with Dr. Howard's opinion.
Okay, I think we have one of her heel. That's another one of her forearm. I think the next one is her heel there at the bottom. Would that be what you would call skin slippage? And how would that differ from what Dr. Howard called her forearm skin slippage?
Well, slippage, this could also be a burn. Now, what I was a little disappointed in Dr. Howard is it would be so easy to take a microscopic section of the heel of the arm and look at it under the microscope. Under the microscope, you can tell what is burned and what is just skin from excess water. Again, this may be a burn. I don't know what caused that, but I definitely know that what we see on the arm is, in fact, exactly a burn.
How quick is it to take a slice of either that heel or the forearm in what you think was the burn and make a determination that it is a burn?
Oh, just seconds. All you do is you make a little cut and you put it into a little cassette that we have at the autopsy, and you fix it. There's a process for fixing tissue. You look at it with a microscope, and you can say, yep, this is definitely a burn, because that will look different than a non-burn.
Okay. Dealing with her jaw, Dr. Howard attributed her broken jaw to the gunshot. Can you tell us whether you agree with that and why you don't?
Absolutely. No. And the reason is, look at where the amount of bruising, number one, and where is that bruising on her body. If it did come from the gun, what would you expect to see? Because I've seen it from guns, but the teeth are going to be broken from the slide coming back. And that's the difference between revolvers and semi-automatics, because that slide, the top part, is going to come back an inch or so. And if it is deep enough into the mouth, you would see a totally different pattern. But this pattern is not from internal trauma. This is a fracture and bruising from external, meaning there was some force applied to the left side of the jaw, and most consistent with a blow on a punch. But this is not what you expect to see from a slide inside the mouth, because the injury pattern doesn't fit that, no broken teeth, and no hematoma, no blood collection on the inside of the jaw, it's all on the outside.
Okay. What's our next one? Same thing, just different angle?
Yes, sir.
So in terms of trajectory, Dr. Howard, can you go to the next one? Yeah, there we go. So Dr. Howard was reluctant to call that a downward trajectory, as was one of our other witnesses today. What do you think about that?
No, clearly, this is downward. And where I put, this is from my report, where I actually put the tip of the arrow was actually a little higher than where the bullet hits. If you were able to zoom in and you look at that second cervical vertebra, look at all those other fragments. Actually, where it actually hit is even a little lower, maybe a half a centimeter lower than where I have the arrow. So it's clearly a downward trajectory, or bullet path, clearly down. It's not straight back. It has to be downward based upon where we see the damage on the x-rays. It's down.
Okay. And then Dr. Howard and I discussed head injuries. I think we have a slide addressing that coming up. Yeah, those things right there. So Dr. Howard attributed to the bleeding there to the incision he made in the scalp. Is that something that you would find correct?
No, I would disagree with Dr. Howard again. Those two areas of hemorrhage are 2 inches away from where the incision was made to reflect the scalp. And as someone who has made incisions at autopsies and reflected the scalp, that this is evidence of trauma to Ms. Howard's scalp. That is 2 areas of hemorrhage leading into the tissue from blunt force trauma. That has nothing to do with the incision that was made at autopsy.
Okay. Then I think we talked about the thumb. Dr. Howard thought that was an abrasion. What do you think of that?
Now, I listened to Dr. Howard's testimony, and abrasion, he said, didn't break the skin. And so I asked the jury to look at this. This clearly breaks the skin, number 1. So it's not an abrasion. And 2, look at the edges, top and bottom of this wound. They are nice and sharp. That says there was some sharp implement that came across that portion of the tongue, something with an edge. There's no abrasion, there's no skin scraped across. There's no laceration, meaning where the skin is ripped and torn from blunt force trauma. This, Dr. Howard, I followed his work for years. I think in his time he was a great pathologist. But this is not an abrasion. This is clearly an incision, something caused by something that had a sharp edge.
Not a gunslide? Not a gunslide, doctor?
No, this is not a slide. I think I shared that with the jury. Having been the doctor for the SWAT team, treated thousands of gunshot wounds in my career, both living and dead. This is not a slide. I've had a slide. This is not what it looks like.
Okay, I think we're done with our PowerPoint here for a moment, but I have a few more questions for you. Dr. Howard talked about how it was common to save tongues in an autopsy. I know that you've told us that you've participated in thousands of them. Has that been consistent with your work?
No, sir. I think the only reason we would save a tongue, and I've only seen it maybe once or twice, is if there's some sort of tongue lesion or cancer that we want to look at under a microscope. But no one routinely saves tongues. I was a little taken aback by that statement, Doctor. We have refrigerators full of tissue in little plastic jars, and I don't know any medical examiner in the country that routinely saves it. In this case, I'm glad Dr. Howard saved it because we were able, Dr. Kamara was able to dissect it and get some more information. So clearly, we thought there was something important about the tongue, and there clearly was. But we don't routinely save tongues.
Okay. Dr. Howard also talked about the fact that he didn't need to see scene photos, much less go to the scene in order to make an assessment of manner of death. What do you think about that?
I couldn't disagree more. And I think I shared with the jury, when I was trained in Scotland and by the forensic pathologists in Scotland, we were mandated to go to every scene. And I even heard, I think Dr. Howard said he hadn't even looked at the scene photos when he did the autopsy. That puts the pathologist or any forensic physician at a huge disadvantage. I want as much information as I can possibly gather or be given in any scene. Which is why I go to scenes, I send my medical students to scenes, I train detectives, crime scene people, the importance of scene documentation and evaluation and collection of evidence. So not going to the scene, not looking at photos of the scene before you do an autopsy, I think put Dr. Howard at a disadvantage by not having all the information that I think would have helped him in his evaluation of Ms. Howard's death.
Dr. Howard also admitted several times to not taking photographs of various injuries. Is that the best practice method of someone doing an autopsy or not?
No, it's not. The way pathologists and crime scene techs and the way I train my forensic nurses and techs is ideally you want a minimum of 4 photos of every injury on the body. And overall, a mid-range and a close one with and without a forensic ruler. And always taking 90 degrees so that that forensic ruler gives you an accurate assessment of the size of any particular wound. I think what was disturbing about Dr. Howard's autopsy, one, there were several injuries that weren't photographed, and 2, he lumped the injuries on the arms. Like he said, there are 10 bruises on the upper extremities. Now, each one of those bruises should be described individually, because you don't want to lump all this one trauma into one sentence. You need to, but each injury, give it its due, and that did not happen in this case.
Is that because it's important to sometimes note pattern injuries?
Yes, it is. Again, I think it's important, and the way I approach it, in the living or deceased individual, is I look at each injury and try and figure out where did that particular injury come from. Is there a pattern to it? If there is, what object or implement created that particular injury? If there's no pattern, all I can say is one close one.
One of the other things that Dr. Howard said was that it was uncommon to have particular hemorrhages in strangulations. Excuse me, it was...
No. Go ahead, I'm sorry.
He said that you would typically find particular hemorrhages in strangulations. Do you agree with that?
No. There's some reason why you may or may not have particular hemorrhages. When you take all asphyxia-related deaths, only 80% have particular hemorrhages. But there are multiple, we call them pale hangings or pale strangulations, where you are strangled to death or hung to death, and you have no particular hemorrhage. Remember those 3 criteria that are required to create a particular hemorrhage anywhere at the bottom. 1, you have to have venous obstruction. So on the back, you have that's blockage of the jugular vein. 2, you have to have arterial inflow. And the analogy is looking at that water balloon. In order to pop a water balloon, we've got to have water going into that balloon. And in order to pop a capillary, you have to have blood being pumped in from somewhere. However, it's not uncommon, particularly when you do what's called a rear naked choke, where you put in pressure here and block the jugular vein, and then you put pressure on the back and sides of the neck to be able to block from 100% of blood that flows to the brain. And so that second criteria of arterial inflow is met, and you are getting strangled to death, and you have no petechial hemorrhage. So, is it common to see petechial? Yes, but you have to analyze and understand why sometimes you do and why sometimes you don't. And you have to have those 3 criteria have to be met in order to have a petechial hemorrhage from a fatal or even near fatal strangulation.
Have you encountered Jeffrey Desmoulin before?
Yes, sir, I have.
Have you had the opportunity to peer review his work?
Yes, sir, I did.
Have you found problems in his work that he has had to address on prior occasions?
Yes, sir. I first encountered one of his reports in a case, Guy versus the U.S. It was an officer involved in shooting. And once I peer reviewed his report, we found several inaccuracies and mistakes. I made the U.S. Attorney's Office aware of those mistakes, and Jeffrey Desmoulin had to correct that on the next report.
Mr. Desmoulin's talked about how much he expected to make from this case. About how many hours do you think you have into this matter?
35, 40 hours.
And
I've never sent you a bill in this case at all. I've never sent you a bill at all. So.
what do you expect to bill us?
I expect somewhere between 15 and 20,000 at the end of the day.
Thank you, Doctor. I don't have any other questions for you, but Mr. Johnson might.
Thank you, Mr. Brenner.
Motion to close court, Your Honor.
Good.
All right, good afternoon, doctor.
Good afternoon, sir.
Now, Dr. Nara testified that the damage to the lip would be consistent with the damage to a gunshot wound. Would you agree with that?
You're talking about the left side of the lip or right side of the lip, or both? Because neither, in this case, are consistent with an intraoral gunshot wound.
Okay, so you would disagree with Dr. Nara on if she said that the damage would be consistent with the gunshot wound?
Again, are you talking about right, left, or left, sir?
The right lip.
I'm sorry, I think you broke up. You're saying
The right
right
lip.
side?
Yes. The left side. The left side of the lip.
Okay, the left side, no, I would disagree with that, for the reasons that the injury, the bruising was on the outside and going down this way. And if she's dead, when the gunshot wound was sustained, one wouldn't get the bruising. So the bruising occurred before the gunshot wound occurred. And when I've seen intraoral gunshot wounds that do cause damage, 100% of the teeth are damaged. And you have to also ask yourself, how would that injury occur if there were some force from inside the mouth that caused the fracture to move outward? And that's not how it happened, because if that were the case, you'd have to have damage to the teeth, the inside, and you expect to see bruising on the inside of the mouth, inside the gum. And where do you see it in this case? You see it on the outside.
Dr. Nara also.
I would not agree with that.
I apologize, doctor. The Zoom sometimes. Dr. Nara also testified that the bleeding would be contained in the mouth. Do you agree with that? I'm not asking for why, but do you agree with that?
Which bleeding? Bleeding from the gunshot wound?
Yes, bleeding from the gunshot wound.
Yes, there will be bleeding. Well, it depends. If her heart is beating, no, I expect the blood to be outside of her mouth. Because with each pump of the heart, you're going to see arterial venous blood spewing out of the mouth. So, do you expect to see some blood from the injury itself pooling inside the mouth after she did? Yes, that can certainly happen. And in this case, it did happen. Because the gunshot wound occurred after she was already dead, we don't see the amount of blood you expect to see if she were alive.
Might be a delay, but can you see my screen?
Yes, sir.
Okay, this is, I believe it's 18F. And this is a photo taken after autopsy, correct?
Yes, I believe it's. I don't know if this is a funeral home or at the autopsy, but clearly she is on a table.
Okay. And you're aware that Dr. Howard took 129 photos, correct?
Dr. Nard took 129 or?
Dr. Howard took 129 photos?
That's correct, sir.
Okay. And you traveled here recently, so you're aware that we have 2 states that are in close proximity, correct?
I'm sorry, you broke up. 2 what are in close proximity?
2 states that are in close proximity?
Yes, Idaho and Washington, yes, sir.
Is it your understanding that as a Spokane medical examiner that Dr. Howard would be allowed to go to the scene of an Idaho case?
In my experience, if a investigator wants, anybody can go anywhere if they want to see a scene. I would think any detective would relish having a forensic physician go to their crime scene.
Are you aware? Sorry.
I don't know any, personally, I don't know any state law that would prohibit Dr. Howard from going to a crime scene in Idaho. I don't know any state law that would prohibit anybody from crossing state lines.
Doctor, do you know what software that the Idaho coroner uses to communicate information to the Spokane medical examiner?
No, sir.
Do you know what information was transcribed from the coroner who was on scene to Dr. Howard prior to the autopsy?
No, sir.
Okay.
I didn't hear Dr. Howard say he didn't see any photos of the scene prior to his autopsy.
That was his testimony, his live testimony you talked last week,
I don't believe so, sir.
3 years after his autopsy?
I'm sorry, the connection was something. Can you repeat the question?
I'll withdraw. Now, would you agree that skin slippage can be sped up by submersion in water?
Certainly.
Would you agree the skin slippage can be also...
Depending on, I'm sorry, sir, depending on how long someone is submerged.
Would you agree that pressure can also increase skin slippage?
Certainly.
Looking at 16G, can you see which direction her body is leaning?
I think you said which direction her body was leaning?
Yes.
Well, what I see is, let's just kind of dissect that. I see her left knee leaning up one way. I see her right knee leaning another way. I see her left arm leaning against the wall. I see her right arm against the wall. And I'd like to bring this up because look at.
And Doctor, I'm going to direct you. I just
Yes,
asked.
the witness should be allowed to finish his answer before he's interrupted by counsel.
It's counsel's witness, he can direct him. I'm allowed Mr. Johnson to interrupt him.
Then, moving on to the bathtub. How much blood went down that drain? Can you tell us that?
Don't know how much blood went down, but we know that from the different photos, there's a little less than an inch of water that gets rained out over the course of a few hours. The blood seems to be pooled right along the center in the bathtub.
On the arm, the bruising. So the bruising did not cause the death, correct?
No, sir. The bruising was part of the assault. It was not causing the death.
And there's a difference between bruising and lividity, correct?
Absolutely, sir.
Your theory of strangulation comes down to lack of blood, correct?
No, sir. The presence matter. The reason I was looking to go back to her lips. There's evidence that her lips were pushed into her teeth. There's evidence of pressure on the left side of her nose. And then the very first photo that was shown in the PowerPoint showed bruising to the front of her neck. So I believe she died of asphyxia. So it's all strangulation, or all suffocation, or combination of both. And that's how she died.
Her head was slumped forward in the tub for a long period of time, correct?
I'm sorry, can you repeat your question?
Her head was slumped forward in the tub for a long period of time, correct?
For some period of time, I don't know how long. It was clearly slumped forward from the time the photo starts until she was removed. But I don't know what, I can't find a long period of time.
The photos you reviewed, do you know the gaps in time in which they were taken?
There's over a period of hours, so let's go back to the photos. We did tell you exactly when the first was taken and the last was taken, but I haven't done it.
Now, I'm showing you, and I apologize, I don't want to dwell to jury, I don't want to dwell on this too much, but showing you what's been marked as 20M. This is photo as part of the autopsy, correct?
Yes, sir.
The autopsy is a traumatic experience to the body, correct?
No, sir, it's not a traumatic experience because the heart isn't beating. We're not beating the body autopsy. I'm a pathologist prior to making decisions with a sharp-edged scalpel to reflect on the tissue. It's not traumatic, no.
But counsel showed you a picture earlier with the face swollen, correct? From one of the corners. That would. Sorry.
Bruising to her mouth and her jaw, and he also showed me this photo of the blunt force trauma to the top of the skull.
The photos taken by the coroner were taken 2 days after autopsy, correct?
There were some photos that were taken by the coroner, yes, 2 days after autopsy. The photo I think you just showed was taken at autopsy, as well as some of the other cases.
You talked about the tongue being saved. Remember counsel talked to you about that?
Yes, sir.
The point of injury with the tongue was unique in this case, correct?
I'm sorry, somebody said something about the tongue? You can eat with the tongue, is that what you said?
I don't know if standing closer or backwards will make it better, but can you hear me better?
Let's try it again. If you repeat the question, please.
The tongue, in this case, had unique injury, correct?
It had a bullet going from top to bottom through it.
From,
That was
sorry, I'm not meaning to cut you off, because when you start a new sentence, I think you're done, so I apologize. So doctor, you said top to bottom, it tipped it back?
so the tongue, the bullet went through the top of the tongue, out the bottom of the tongue, and into the spinal cord.
So he made a correct decision to save something of potential evidentiary value, correct?
Yes, sir, it did.
Okay. The tongue is a muscle?
The tongue is a muscle with sensory organs built into it as well. These buds. Yes.
Now-
It's practical.
I apologize. You testified a couple weeks ago that you reviewed the materials in 2021, correct?
That's correct, sir.
You were provided the autopsy photos in 2021?
Yes, sir.
You were provided the scene photos in 2021?
Yes, sir.
You were provided the autopsy report in 2021?
That's correct, sir.
You provided the coroner photos in 2021?
That's correct, sir.
You stated later that you were asked to review it maybe on one other occasion? Is that right?
I was asked to initially review it in 2021, sir.
Okay. And then you reviewed it, at that time you needed more information?
That's correct, sir.
And you were asked to review it one more time?
After doctors had revealed after Dr. Nara had done a section. That's correct. And there's additional information.
Okay. And you did testify, I'll withdraw. No further questions. Permission to retrieve the exhibits.
Yes. Mayor? Thank you, Mr. Johnson. Redirect, Mr. Rivera.
Hey, doctor, we are looking at, I think it was 16G. It's a photograph of Kendy in the tub. And I think you were describing that to Mr. Johnson when you were cut
Yes.
off. Do you remember that?
Yeah, if you can pull it up, I can't see it. Because I think there's some important information that I would love to explain to you.
All right, let's see if we can get that PowerPoint back up. So that burn was on the inside of the right arm, right?
Yes, sir.
And counsel was asking you some questions about how pressure can lead to skin slippage, right?
Yes, sir.
Now, when we're looking at that photograph, you were starting to describe how her right arm was placed to include her forearm. Can you continue with that?
Yes, sir. What I wanted the jury to understand is that I think the defense counsel requested which way was her body leaning. Well, it's kind of leaning both ways. Look at where there is actual pressure on the body. If you look at her left arm, left elbow, it's up against the wall. There's no skin slippage on that part of the arm. And let's go to the right arm. What part of her right arm is actually in contact with the bottom of the tub? It's the elbow. There's no skin slippage at the elbow. And then look at the inner surface of her right arm. Her wrist is up at the top of the water. So her elbow's in contact. There is no pressure against the inside of her arm. No, it's not there. That part of the arm is floating in the water. So to say, to make the assumption that this part is because of pressure against the bathtub, this photo, there is no pressure against the inside of her right arm against the bathtub, period. So it's not skin slippage from pressure, because there's no pressure on that part of the arm. What we're seeing on the inside of her right arm are thermal injuries. Those are second-degree burns. And look at what part of her knees are in contact. It's the outside of the knees. Do you see any skin slippage there? No. But even more important, think about if you spread your legs in a frog leg position, which way are your feet now in contact with the bathtub? What happens is your feet are going to lift up. So, but I think getting back to the original question about what caused this skin slippage on the inside of the right arm, they're thermal injuries. There is no pressure from the bathtub, bottom of the tub, on the inside of the right arm that would cause that. It's free floating in water. I think that was what I wanted to accomplish.
Okay, if I take that off if you'd like. So, counsel asked you a couple questions about being involved in this case in 2021 and then coming back and taking a second look at it later after you got more information. Have you done that before?
Yes, sir.
Can that be common in cases like this, in cases involving staged crime scenes?
Yes, sir.
Why is that?
The reason it's common, the reason that's my personal stance, before I render any opinion in a criminal case, I have to be 100% convinced. And I call that reasonable medical and scientific certainty. That I'm going to render an opinion if you have criminal implications for a potential defendant. My opinion, before I'm going to put my name on the line, is I have to be 100% certain that my opinion is based on all the evidence that I have. And when you first presented that to me back in 2021, I said, I need more information, or I can put pen to paper and tell you, did I think it was a homicide? Yes. But was I ready to put that in writing? Not until I got additional information.
Are you 100% convinced that this was asphyxia?
Yes, sir.
And are you 100% convinced that this is a homicide?
Yes, sir.
All right. Well, thank you. No further questions.
Thank you, Dr. Slott, for your appearance. We'll let you sign off.
Thank you, Doctor. Have a great day.
You too.
Good on the rebuttal. That was the extent of a rebuttal case, Judge.
Thank you, Mr. Rivera. All right, members of the jury, you've now heard the entirety of the evidence, and so we're going to take a recess. I'll just be honest with you, this is a longer recess. And just so you know what's happening, I don't want to do this for one third. I'll be preparing the final jury instructions that will be provided for you. While I'm doing that, counsel's will be organizing their thoughts for the closing arguments and things like that. And so this just honestly takes a little while. But I anticipate coming back. I'll be reading you the final jury instructions. The attorneys will be giving you their closing arguments. I suspect that will take us close to the end of the day. And just so you know as well, when it comes to deliberations, I'm not supposed to keep you here after 5 o'clock unless you all unanimously decide you want to stay and deliberate longer. And if you do that, you can. But if we're going on a regular schedule, I would anticipate you might get into deliberations and probably let you go at 5. Again, I'll let the jury make the decision when we get to that point. If you are unanimous that you want to stay longer and keep talking, but everyone would have to agree because I can't keep anybody past 5 if they can't. So, but anyway, I just wanted to give you a sense of where we're headed with this. So we'll be in recess at this time again. I'll admonish you not to discuss the case yet among yourselves, and I would just do that soon. Do not discuss the case among yourselves or with anyone else. And I kind of apologize in advance that this is a longer break. I want you to kind of understand why it is. Okay, we'll be in recess at this time. Council, I don't know if you got a chance to see that I did ask my law clerk to send you the verdict form as well. It's pretty good. Obviously, that's the first count. It's just guilty, not guilty. The second count hasn't included offense, so it starts with a question and then goes to the second count. Just take it when you get a chance to look that over. And then I know Mr. Johnson wanted a little bit of time, so will the parties be ready to be back at 3 o'clock, or is that sufficient?
Yes, sir.
Is that for the sake?
Yes.
Okay. Hey, have you seen the verdict form yet or not?
I took a look at it during testimony.
Judge, my only feedback is whether or not it's confusing calling what is actually the second question that the jury is being asked to answer question number 1.
We were back and forth on that. If the parties want, I can label the first one question 1, question 2, question 3. Okay.
Thank you.
On the fence on that. Mr. Johnson, is it look right to you?
Yes, Your Honor, I would agree.
Okay. We'll just call the first one question 1. Okay, thank you, counsel. We'll be back at 3 o'clock.
All rise.
parties ready to proceed?
Yes, sir.
Mr. Honor.
Okay, let's bring it through. Yeah, make sure that's not broadcast. Thank you. You may be seated. All right, members of the jury, having heard now the entirety of the evidence, I'm going to provide you what are called the closing jury instructions. As I indicated to you earlier, I'm going to be reading these instructions to you. I don't do that to be impersonal, because you're going to each get your own copy of the instructions that I provided. And I want to make sure I don't, in speaking off the top of my head, forget something or miss things. So I'll now provide these instructions to you. Instruction number 14. You have now heard all of the evidence in the case. My duty is to instruct you as to the law. You must follow the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree or don't understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any I tell you, it is my instruction that you must follow. Instruction number 15. As members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of 1. Sworn testimony of the witnesses, 2. Exhibits which have been admitted into evidence, and 3. Any facts to which the parties have stipulated. Certain things you have heard or seen are not evidence, including 1. Arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. 2. Of things which are not evidence. Testimony that has been excluded or stricken, for which you have been instructed to disregard. And 3. Anything you may have heard or seen when the court was not in session. Instruction number 16. In order for the defendant to be guilty of count 1, domestic battery, the state must prove each of the following. 1. On or about July 10, 2020. 2. In the state of Idaho. 3. The defendant, Daniel Charles Howard, committed a battery upon Kendy Howard by causing injuries to him. 4. While they were household members. And 5. In doing so, the defendant inflicted a traumatic injury or injuries upon Kendy Howard. If any of the above has not been proven beyond reasonable doubt, you must find the defendant not guilty. If each of the above has been proven beyond reasonable doubt, then you must find the defendant guilty. Persons are household members if they are married to each other, were ever married to each other, or have a child in common, regardless of whether they have been married or are cohabiting. Traumatic injury means a condition of the body such as a wound or external or internal injury, whether of a minor or serious nature, caused by physical force. Instruction number 17. A battery is committed when a person, 1. Willfully and unlawfully uses force or violence upon the person of another, or 2. Actually, intentionally, and unlawfully touches or strikes another person against the will of the other, or 3. Unlawfully and intentionally causes bodily harm to an individual. Instruction number 18. In order for the defendant to be guilty of count 2, first-degree murder, with malice aforethought, the state must prove each of the following. On or about February 2, 2021, in the state of Idaho, the defendant, Daniel Charles Howard, engaged in conduct which caused the death of Kendy Howard, to wit, by asphyxiating her. 4. The defendant acted without justification or excuse. 5. With malice aforethought. And 6. The murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time during which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not premeditation. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond reasonable doubt, then you must find the defendant guilty of first-degree murder. Instruction number 19. Murder is the killing of a human being without legal justification or excuse and with malice aforethought. Instruction number 20. Malice may be express or implied. Malice is express when there is manifested a deliberate intention unlawfully to kill a human being. Malice is implied when 1. The killing resulted from an intentional act, 2. The natural consequences of the act are dangerous to human life, And 3, the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of time. It only means that the malice must precede rather than follow the act. Instruction number 21. If your unanimous verdict is that the defendant is not guilty of first-degree murder, you must acquit him of that charge. In that event, you must next consider the included offense of second-degree murder. Instruction number 22. In order for the defendant to be guilty of second-degree murder, the state must prove each of the following. 1, on or about the second day of February 2021. 2, in the state of Idaho. 3, the defendant, Daniel Charles Howard, engaged in conduct which caused the death of Kendy Howard, to wit, by asphyxiating her. 4, the defendant acted without justification or excuse. 5, with malice aforethought. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of second-degree murder. If you find that all of the above have been proven beyond reasonable doubt, then you must find the defendant guilty of second-degree murder. Instruction number 23. Videos, text messages, and various exhibits have been admitted into evidence that were redacted by order of the court. You are instructed that you are not to concern yourself with any redactions that have been done to any of the evidence that has been admitted in the case. Instruction number 24. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, you were admonished that it could not be considered by you for any purpose other than the limited purpose for which it was admitted. Do not consider such evidence for any purpose except the limited purpose for which it was admitted. Instruction number 25. It is alleged that the crime charged was committed on or about a certain date. If you find the crime was committed, the proof need not show that it was committed on that precise date. Instruction number 26. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 27. You have been instructed as to all the rules of law that may be necessary for you to reach a verdict. Whether some of the instructions will apply will depend upon your determination of the facts. You will disregard any instruction which applies to a state of facts which you determine does not exist. You must not conclude from the fact that an instruction has been given that the court is expressing any opinion as to the facts. Instruction number 28. The original instructions and the exhibits will be with you in the jury room. They are part of the official court record. For this reason, please do not alter them or mark on them in any way. The instructions are numbered for convenience in referring to specific instructions. There may or may not be a gap in the numbering of the instructions. If there is, you should not concern yourselves about such gap. Instruction number 29. I have outlined for you the rules of law applicable to this case and have told you of some of the matters which you may consider in weighing the evidence to determine the facts. In a few minutes, counsel will present their closing remarks to you, and then you will retire to the jury room for your deliberations. The arguments and statements of the attorneys are not evidence. If you remember the facts differently from the way the attorneys have stated them, you should base your decision on what you remember. The attitude and conduct of jurors at the beginning of your deliberations is important. It is rarely productive at the outset for you to make an emphatic expression of your opinion on the case or to state how you intend to vote. When you do that at the beginning, your sense of pride may be aroused, and you may hesitate to change your position, even if shown that it is wrong. Remember that you are not partisans or advocates, but are judges. For you, as for me, there can be no triumph except in the ascertainment and declaration of the truth. As jurors, you have a duty to consult with one another and to deliberate before making your individual decisions. You may fully and fairly discuss among yourselves all of the evidence you have seen and heard in this courtroom about this case, together with the law that relates to this case as contained in these instructions. During your deliberations, you each have a right to re-examine your own views and change your opinion. You should only do so if you are convinced by fair and honest discussion that your original opinion was incorrect, based upon the evidence the jury saw and heard during the trial, and the law has given you in these instructions. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. However, none of you should surrender your honest opinion as to the weight or effect of the evidence, or as to the innocence or guilt of the defendant because the majority of the jury feels otherwise, or for the purpose of returning a unanimous verdict. Instruction number 30. Upon retiring to the jury room, select one of you as a presiding officer who will preside over your deliberations. It is that person's duty to see that discussion is orderly, that the issues submitted for your decision are fully and fairly discussed, and that every juror has a chance to express himself or herself upon each question. In this case, your verdict must be unanimous. When you all arrive at a verdict, the presiding officer will sign it and you will return it into open court. Your verdict in this case cannot be arrived at by chance, by lot, or by compromise. If, after considering all of the instructions in their entirety, and after having fully discussed the evidence before you, the jury determines that it is necessary to communicate with me, you may send a note by the bailiff. You are not to reveal to me or anyone else how the jury stands until you have reached a verdict, or unless you are instructed by me to do so. A verdict form suitable to any conclusion you may reach will be submitted to you with these instructions. And you'll receive, these are the original instructions. I will go back with you. You'll each have your own set. And then you'll also see an original verdict form, and I'll just read it to you now. The verdict form will say State of Idaho versus Daniel C. Howard, is case number verdict. And it reads, we, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Count 1, question 1. Is the defendant, Daniel C. Howard, guilty or not guilty of domestic battery? And then you check the box either not guilty or guilty. Count 2, question 2. Is the defendant, Daniel C. Howard, guilty or not guilty of murder in the first degree? Again, you check not guilty or guilty. The form then reads, if you unanimously answered question 2 guilty, then you must sign and date the verdict form. So you would just flip over and sign the last page. If you unanimously answer question 2 not guilty, then proceed to question 3. Question 3 asks, is the defendant, Daniel Howard, guilty or not guilty of second-degree murder? And then you would check not guilty or guilty. When you flip to the back page, it says, once you have selected a verdict for each count, date and sign the verdict form and tell the bailiff that you are done. And then the presiding officer would date and sign. All right. This time, we'll now hear closing arguments. State will go first. You may proceed.
Thank you, Your Honor. I'm just going to start with the D10.
That's fine.
Who was Kendy Howard? Kendy Howard was fun. She was communicative and engaged in her life, said her family, said her friends. She loved her parents, her brother, she loved her children, and especially her granddaughter. She had hobbies, passions, things in her life that brought her joy. And in the months before Kendy Howard's death, Kendy was moving towards something. She was moving towards a new future, a new house, a new relationship, a new life that was away from the financial, emotional, and psychological control of the defendant. When you have eliminated the impossible, whatever remains, however improbable, must be the truth. Throughout this case, the state has shown you Kendy Howard did not kill herself. Kendy Howard did not kill herself because Kendy Howard was full of life, moving towards that future. And Kendy Howard did not kill herself because Kendy Howard was dead when she was shot through the mouth. The defendant killed Kendy Howard. Now back in July of 2020, Kendy was very much still under the financial control of the defendant. And on this particular day, they were, once again, arguing about money. As Michelle Lampert told you, Dan's money was Dan's money, and Kendy's money was Dan's money. And messages between Kendy and the defendant on that day tell us that they were, in fact, fighting about money. Now I'm pissed, he says. She would later confirm with Dan Prado that the fight was about money, and then it got to a blowout point. Later that evening, she would call 911 frantic and terrified. She would tell that 911 operator she heard something, a shot, but she doesn't know guns. Later, when law enforcement did arrive, she would not report anything. And who was standing next to her? Her son Wyatt. She didn't report in front of her son. But she does tell the next day. She's texting, communicative as always, with her friend Michelle Lampert. And you can read these entire conversations. They're available to you. She sends her these ruse photos as well. She shares it with Dan Prado as well, talking about how this happened and implying who did it. Talks to Dan Prado about being made to erase her phone. Because as Ms. Markhoffer, the prosecutor investigator, told you, Kendy likes to take selfies. There were a lot of selfies on her phone, and we have some from this time period. That one of her ear was taken at 8:25 p.m. on July 10th. And then there were the photos that were on her phone that she didn't send. She took lots of bruise photos. Photos to her chest, to the front of her arm, to the back of her arm, to her other arm on the other side, underneath her arm, and to her neck. Kendy didn't share these photos. She took them. And these are dated July 12th. Now, in order for the defendant to be found guilty of count one domestic battery, the state must prove several things. on or about the 10th day of July. That's when Kendy says it happened, that evening. In the state of Idaho, their home in Ethel, the defendant committed a battery upon Kendy Howard, causing injuries to her. And certainly in those conversations, they were household members, they were still living together and married at the time, and in doing so inflicted a traumatic injury. All of those bruises on every part of Kendy's chest, under the arm, on the side, those weren't made from slipping on a trolling motor. It is convenient that the defendant's best friends, Brett Gunderson and Terry Maitland, remember that 4 years ago, exactly on July 10th, they saw Kendy slip on the trolling motor. But again, those photos from inside of Kendy's phone, they don't match that timeline. Because Kendy and Dan pulled the boat out and went to Dvorak on July 15th, 5 days after this event. The bruise, seen in pictures at Dvorak, it's fading. This happened on July 10th, and it didn't happen from slipping. Maybe slipping might explain that one on the chest that was visible to other people, but it doesn't explain all those other bruises. Now, Dr. Bostaff testified, and she talked to you about all of the reasons that victims of domestic violence do not report. Why they don't report to law enforcement, and why they don't share details with their family, with their friends. Why they stay in relationships where they are ridiculed, where they have mean comments said to them, where they are controlled, isolated, and abused. Brooke took the stand. She told you things that she's heard her stepfather say to her mother. Things like fat, bitch, dumb. But what did change in July is that Kendy got serious about leaving. She started talking with her coworkers, and Kendy didn't share with her coworkers because Kendy was communicative. Like how she told her coworker Matt Kulak. She didn't get that bruise at work. But she starts talking to him about how she's going to be leaving that job. She's going to be leaving her job for many years, and she's moving to Kootenai County. And she's asking her bosses for references and to look at job postings. And she's talking to her friends about maybe she's not going to stay with the hospital. Maybe she's going to follow her passions, open up a little antique store. And Kendy is working with her boyfriend, who was a realtor, to look at houses down in Kootenai. And on January 22nd, her offer on that house in Kootenai was accepted. She signed paperwork, entered into a contract, and even back on January 22nd, she was getting advice from Dan Prado that she would have to get a quitclaim deed. She was communicating about this, she was asking questions, she was getting that information that she needed. She was also talking with her friends about this idea that she's going to leave Dan Howard. She's telling them about her feelings. She's sharing. She's engaged with her friends and her family. And what's more, she's supported. Her friends are telling her, you know that we'll support you. You know that you've got somewhere to go if shit gets bad. And Kendy, she's excited. January 24th, she is out shopping. She's getting to choose decor for the house that's going to be all hers. She's getting the hot tub that she's always wanted. She's getting to make those purchases for her future. And yes, we know again from Kendy's phone, Kendy was having thoughts. She was wondering about things. There's a screenshot, never sent, in her phone, saying, why not agree to just keep each other's own pension? Only one person she would have sent that to. But Kendy wasn't a person to keep her thoughts just in her mind. Kendy sought out information. Like on January 26th, Kendy reaches out to her friend Zach Jones. Says, hey, how much is my house worth? How much are those lots in Spirit Lake worth? And even talking with him about how she knows she's going to have to get something written up for the new house in Kootenai. And maybe also talking to him about some of her fears. But that isn't where Kendy stopped. January 27th, Kendy met with Matt Wakes, the attorney. And in that period of time, Kendy found out that she was entitled to the $2 million in community property that they had. She would be entitled to half. Half of the house in Apple, half of the lots in Spirit Lake, all of the toys that they had accumulated over the course of their 26-year marriage, half of the retirement accounts, including Dan's retirement account and cash. Because Kendy was seeking out that information. She was getting informed, and she was sharing that information that she was learning from mom and her friends. January 28th, Kendy does something for her. On that day, she goes and she makes an appointment for a mommy makeover. January 28th, she makes that appointment. But that appointment is set for later in February. Because as we know, Kendy had some body image issues, likely fueled by the abuse that she had sustained in her marriage from her husband. She had been on diet pills that she got from Dr. Ford, her family doctor, as well as from Kristen Miller at the Real Weight Loss Clinic. But Kendy was moving forward, looking forward, making those future plans. And during this time, Dan's up in Alaska. And he's getting bits and pieces of this, and they're starting to text and talk about it, and he said, we can talk about this when I get home. On January 28th, Kendy goes and picks him up from the airport. Drives to Spokane, picks him up. And Kendy, ever communicative, is talking with her childhood friend Tana. She's telling Tana on the 28th, I asked for a divorce. Tana says, what's his reaction? And he says, not good. But despite that, Kendy tells Tana, when Tana asks, how do you feel? She says, never felt so good. That feeling did not last for Kendy. Because Kendy went to bed, And then the next morning, early in the morning hours of the 29th, she woke up. She woke up to the defendant standing over her in black or dark colored clothes, wearing black latex gloves, holding something in his hand that was probably like a pillow. His other hand she couldn't see. And Kendy saw a look in his eyes that terrified her. She opened up a line to Dan Prado. She managed to get to the bathroom, and what Dan Prado heard through that open line, well, it terrified him. He could hear the fear in Kendy's voice. He could hear the defendant's voice. So he called Jamie and Wendell, people that he had his own relationship with, his own friendship with, and told them, I'm scared for Kendy. And so they called 911, and Wendell got a hold of Kendy on the phone. And Wendell, as he is talking to Kendy in that bathroom, what does he hear? He hears Dan Howard's voice saying, I would never hurt your daughter. Wendell stays on the phone until law enforcement gets there. And when they get there, and you all got to watch the video, what they find is a Kendy who is barely speaking above a whisper. All she wants to do is pack a bag and get out of there. And finally, away from the defendant, as the defendant's downstairs with Deputy Broughton, Deputy Traw is able to ask Kendy, what is going on here? What do you think was going to happen? She tells him, he was going to kill me. She doesn't say it just once, she says it several times. Downstairs, the defendant relaxed on the couch, doesn't understand why everybody's there. And so Kendy is walked out by the deputy. She gets in her car and she calls Dan Prado. They talk for almost an hour. And she tells him all of those same details. She calls Michelle Lampert. They talk for almost half an hour. Tells Michelle all those details. Her story is consistent. She gets down to Kendy. She talks with her parents. Wendell, he goes and gets his own 380 magazine clip, tosses it on the floor. And Kendy says, yes, that's what I saw on the floor. But when I went back to look for it, it was gone. The defendant, meanwhile, well, he is blowing Kendy's phone up, texting her saying this was all a big misunderstanding, telling her that she's safe here. Doesn't stop there, though. Over the next course of that day, he calls Kendy 23 times. 16 times between 6 a.m. and 10:30, and then 7 more times later that day. But that isn't the only way he's trying to get a hold of her. He is sending her message after message, telling Kendy, love with a changed man. What's not to love? Sending her photos of them from happier times, all to lure her back home. Come home. This is a big misunderstanding. You are safe here. And despite her family and Dan Prado's pleas to the contrary, she does. She goes back. She tells them, look, I've got an eye appointment I've got to keep. I've got to give my notice at work. I've got to finalize this divorce. She tells them, he got caught. He's not going to do anything now. And she does. She goes back. January 30th, she goes and she keeps her eye appointment and she puts in an order for 2 pairs of prescription glasses. Glasses that she will have to pick up in the future. Meanwhile, she is again still ever communicative, talking with people, and she's talking to the defendant. And around 7:33 p.m., during their conversation, she sends the defendant the listing for the house in Candy Eye. A listing that has Dan Prado's name on it, Dan Prado's face. That night, when she gets home, it's a different Dan, new attitude. Now he's willing to sit down, he's willing to do the paperwork with her. He seems okay. And they do. They sit down and they fill out asset division. They fill out the divorce papers. And Kendy, ever communicative, she's sending these to Dan Prado. This is what we're talking about. This is what we're doing. And in that conversation with Dan Prado asks her, what are you leveraging for the quitclaim deed for the Candy Eye house? That was in there too. It's part of the trade. He's hard to read Kendy's text, but he's hooded with that. House part of trade, no guns, mounts, and safe for deed. That conversation indicates Kendy, the defendant, talked about the Candy Eye house on January 30th. So February 1st, after having this conversation with the defendant the night before, Kendy moves forward. She's moving forward with this plan to divorce the defendant. She reaches out to Courtney Lampert. They talk. They set a plan. Courtney's going to come by the house on Thursday, walk through it, get the listing ready. Courtney even indicates she's got a buyer lined up for $800,000. Kendy is moving forward with this plan. Meanwhile, Dan heads down to Lucille. He stops in Lucille. He picks up Brian, and as they are driving down, Brian testified. Brian told you that Dan pulled out his phone and showed Brian the listing of the Candy Eye house. That same listing that Kendy had sent to him. That same listing that had Dan Prado's face, Dan Prado's name. They talked about whether or not Kendy was having an affair. They talked about their suspicions and whether or not Dan Prado was that bad. By the time that Dan Howard talks to Detective Sergeant Lawton, he's downplaying that. Told him I didn't care much at that point. That's not what Brian said. Brian said that Dan was up pacing all night. That Dan was pacing all night, that Dan was driving erratically, that Dan was upset. February 2nd was Kendy's last day. Started out totally normal. Kendy went to work, as she did, based on her schedule. She clocked out around 4 o'clock, on schedule. Her coworkers who worked with her that day testified she didn't have any injuries to her that day that we saw. She didn't have any burns to her arm that we saw. We didn't know anything about Kendy being injured at work. And it was a good day, because while Kendy was at work, down in Kendy, a home inspection was going on. And Kendy, of course, ever communicative, she's talking with Dan Prado about this. Everything is good. Home inspection went great, closing can move forward. She's also telling Dan Prado he's still trying to hang on. Him being independent. Not fully accepting this is happening, still bleeding. Kendy, she is resolved. She is moving forward. She is ready to keep going. She wants the house in Kootenai. She wants the divorce. After work, she goes and she gets her nails done in Liberty Lake. Nina Pham testified, and he was in a good mood. No injuries to her hands, her arms. Her mom's nervous, erase everything off the phone. Kendy stops and gets McDonald's on the way. That McDonald's is about $7, food for her. She then talks to Dan Prado on the way home. For a few minutes, testified that she seemed good. She was in a good mood. When Kendy would go home, she would talk with her mom that evening. And what were they talking about? Mundane stuff. About the house in Kootenai, decor, dressers. Things looking forward to Kendy's new future. And Dan came home from Lucille that day. Dan came home on February 2nd. And so that evening, 10:48 p.m., the 911 call comes in. And in that 911 call, Dan Howard tells the 911 operator she's dead. She's dead, she's dead, she's gray, she has no pulse. She's cold. Dan Howard, a long-time law enforcement officer who had been to many fatal car accidents or other crime scenes, tells the 911 operator she's dead. I checked her pulse. Yet, when the deputies get there, all of a sudden he's asking them, what's going on? What are you doing? What's happening? Acting as if he doesn't know what's going on with his wife. He's also repeatedly making vomiting noises, but they notice that there's no actual vomit. He's wailing and making crying noises, but they notice that there are no tears. They also notice that he's got fresh deodorant stains on his shirt. He would later tell Sergeant Lawton they took a shower around 4, and now it's well after 11. The defendant gives a version of these events. He tells Sergeant Lawton he got back that afternoon. We know it's true. That she picked up something from the deli. Well, she got McDonald's on the way home. And then we went down there and finalized everything, but she flipped out when she realized that the house had to be liquidated, and she went upstairs. Well, they've been talking about this house. Kendy knew what she needed to do to get the house from the divorce, and it wasn't a house that she even owned yet. And so, according to the defendant, instead of going upstairs and reaching out to her realtor boyfriend, her realtor friend, her family, or anyone else, he says that he can hear the bath water running. Anyway, he says, I heard something hit the floor. Didn't sound like a shot. The same defendant, his father testified that he's completely deaf in one ear. So he is a deaf in one ear, prior law enforcement officer who was on SWAT and was a firearms instructor. He cannot recognize the sound of a gunshot going off in a small room with an open door in his house. But he can hear the bathwater running? He also goes on in his interview to tell Sergeant Lawton that, was the water still running when you went up there? No, trickling. There's a trickle. Yeah, I shut that off. Must have been going in the overflow. Did he shut off the water, or was it going in the overflow? Either way, Deputy Wheeler got on scene. That water is under the overflow. And again, I hear the water running, and it sounded like something hit the floor. Detectives asked him, how long was it after you heard that sound of something hit the floor? She went upstairs. An hour and a half, he says. That long? Sergeant Lawton asks. Yeah, he says. Yet, Deputy Wheeler, again, that first officer on scene, told you that when he went in that bathroom, there were bubbles in that bath, and then he held his hand by the water and it felt warm. There were other odd things that stood out to Deputy Wheeler in the beginning. One was the scene in the bathroom. There's a purse sitting on the counter. There was a gun magazine in that purse. Her phone and glasses are very neatly placed by that magazine and by that purse, not within arm's reach of the tub, however. Downstairs, the dryer was running, and Detective Northrup would later tell you that based on this timestamp from Deputy Wheeler's body camera, and the 6 minutes left on the dryer, that would have meant that that dryer was started within minutes of that 911 call being placed. In order for the defendant to be guilty of count 2 first-degree murder, malice aforethought, state must prove these elements. On or about the 2nd day of February, you know that's the date that this all happened, in the state of Idaho, at her house in Apple, the defendant engaged in conduct which caused the death of Kendy Howard. No one else in that house who caused Kendy's death, either the defendant or Kendy herself, as alleged by the defense. The defendant acted without justification or excuse. There's no self-defense claim here in this case. With malice aforethought, basically did he act disregard for life, and whether that murder was willful, deliberate, and premeditated. Throughout interactions with law enforcement, both outside the house and inside the house, Ken Howard kept his face covered. No tears, no true signs of emotion that deputies could see. They looked for those tears, but they could not find them. There were lots of other things that they started to notice that just seemed strange. Like in the floor of the bedroom, there was broken glass. Deputy Coroner Lynn Acevedo, who has been to thousands of deaths, would also note that glass on the ground. Detective Euler would note when he went downstairs that the wood-burning stove was absolutely cooking. He comments on in the video that it's uncomfortably hot down there. And then there's a humidifier kettle sitting on top of that stove. Divorce paperwork still sitting there on the bar counter, but now it's changed. It's changed in that Kendy's house split is now on the paperwork. Still in Dan's handwriting, different color pen. And again, Kendy, at this point, has been well informed by attorneys, by her boyfriend, by her friend, that this house isn't an asset. This house is a debt. This is something that would have to be dealt with in the divorce through a quitclaim deed. And she didn't even own the house yet. Closing had not occurred. The body itself seems strange. The body is unnaturally positioned in the tub. Her feet are scrunched up at the bottom. There's no splatter on the hands from holding the gun. And as Randy Beasley told you, what little blood is there on the body? Well, it's moving against gravity. It's moving in the wrong direction. It's curling up and around her nose, up her cheek, and on her breast. It's moving down with gravity, but then over. And Beasley told you that is indicative of a body that had moved. And as law enforcement goes through this scene, they are finding more and more things that indicate to them that this scene is staged. Small details like the fact that the shampoo and conditioner bottles are facing out of the tub. Details like the fact that the purse, the cell phone are not in reach of the tub. The fact that there's no towels within reach of the tub other than those decorative towels. There's no clothes in the bathroom for Kendy to change into. There's bubbles, the temperature of the bath is warm, the body itself looks strange. Later, they would find out that Dan's DNA was not on those bullets in that magazine in the tub, but it was on the bullets in the magazine in the purse. Overall, there are lots of things about that scene that cause investigators to say to themselves, this doesn't look right. Well, very quickly after Kendy's body was removed from the tub, she was taken to Spokane for her autopsy. There's a lot of evidence about how long Kendy sat in that tub, but then her autopsy was 11 o'clock that next morning. About 11:30 is when it got started. And John Howard, at the end of his career, got a body, and he looked at that body, and he saw an obvious cause of death, a gunshot wound to the mouth. And he told you that it's important to document injuries. Yet, he did not document injuries. He didn't even document the injuries that he noted in his report. Didn't bother to take pictures of them. Just did a very superficial examination. He also told you that he did not review crime scene pictures, then or now. He didn't review any of the investigation, then or now. He didn't review any of the additional work that had been done by investigators in this case. And then Acevedo, next day, or excuse me, 2 days at the funeral home, she sees Kendy's body laying out and she thinks, whoa. Looking at that body does not look like a body just committed suicide. And ultimately, through the autopsy photos, through Lynn Acevedo's photos, through the review by other medical doctors, this is what Kendy Howard's body looks like. Each of those dots is an injury to Kendy's body. Sure, maybe 1, 2 bruises could be from tripping over a box at work, but not this. Part of what you have to consider in your deliberations is malice. Malice is expressed when there is a manifestly deliberate intention unlawfully to kill a human being. Malice is implied when the killing results from an intentional act. The natural consequences of that act are dangerous to human life, and the act is deliberately performed with knowledge of that danger and conscious disregard of human life. Ladies and gentlemen, the state would argue to you that both are present in this case. The actions of the defendant demonstrate a deliberate intention to kill Kendy Howard, express malice, and the actions taken by the defendant to asphyxiate Kendy Howard, knowing how dangerous that conduct was, is implied malice. Ladies and gentlemen, you have both. Malice aforethought simply means it does not imply there has to be a deliberation or lapse of time. It simply means that the malice must precede. Did Kendy Howard die of a gunshot wound? Even at the scene. This is Kendy Howard at the scene in a body bag. That is bruising to her neck. Seen still later at the funeral home. And Dr. Smock told you that bruising on that part of the neck is consistent with a rear naked choke, consistent with a carotid restraint, consistent with a type of move that could result in complete occlusion of blood flow to the brain, which would result in a lap petechia. Dr. Smock also talked about her jaw. Her jaw that was broken, fractured on the left side into multiple pieces, here and here. And that there was bruising, at the time of autopsy, you can see in other photos as well, from that. Dr. Smock told you, bruising occurs in life. It can show up after death, but bruising occurs in life. That fracture is a result of blunt force trauma that occurred before her death. Gary Tolson talks to you about the carotid restraint as a police technique, what it is, what it's been taught, how it's utilized. It is lethal force. And it's lethal force because officers have to know they can kill somebody. And Leslie Lehman told you that when she was a trooper with Dan Howard showed her how to do that move. He taught her. They did it together, and they talked about carotid restraint. Because again, ladies and gentlemen, this move is the carotid restraint. This is a chokehold that crushes the windpipe. This blocks blood flow. Dr. Smock pointed out that there are other signs of asphyxiation to Kendy Howard. The fact that she has damage to her lip, the fact that she has damage to this side of the lip caused by her teeth being pushed in, the fact that she's got bruising to her nose, and again the bruising to the neck. These are the results of pressure. And Kendy Howard's body, bruised. Bruised in pattern form, bruised in protected areas. And again, ladies and gentlemen, many of these bruises, and these are bruises, not lividity, are captured because Lynn Acevedo had the forethought to take these photographs at the funeral home, not because Dr. Howard took photos during his autopsy. Dr. Howard didn't even take a photo of the backside of the body. It wasn't covered in blood. And then, of course, there are the lacerations. There are lacerations to the feet, consistent with walking on broken glass, lacerations to the hand, and as has been excessively discussed in this case, not slide light. And then there is the burn to her arm, the burn seen at autopsy and then later at the funeral home. Dr. Howard would have you believe that that is skin slippage. Well, Dr. Stewart, whose specialty is burns, who is at a level 1 trauma center in Seattle, who routinely examines potential burns through telemedicine, told you, no, that is a thermal burn caused by a hot liquid. Where is there a source of hot liquid? Hot enough to burn this into a 2nd-degree burn? Down by the stove, sitting on top. What else Dr. Stewart told you is that 2nd-degree burns are actually the most painful kind of burn. 3rd-degree burns, you burn right through those nerve endings. But 2nd-degree, like this, you're just exposing all those nerve endings. And a person with a 2nd-degree burn like this is not going to go stick her arm in a bubble bath. Now again, Dr. Howard pointed out some skin slippage on that foot, but not on the other foot. And he told you that slippage occurs when there's pressure. Well, ladies and gentlemen, as Dr. Smock pointed out today, this arm, and again, it's that underside of the arm, there's no pressure there. That arm on the sides up against the tub, but where that burn is floating in the water, not skin slippage. And trajectory. yes, many interoral gunshot wounds are suicide. But most of those interoral gunshot wounds go up to the brain to kill the person. They have an upward trajectory. And as Dr. Desmoulin talked about, an upward trajectory is a more ergonomical trajectory for someone attempting to shoot themselves. Downward trajectory is associated with homicide. It's associated with someone else holding the firearm and shooting into the person's mouth. And although Dr. Howard and Dr. Desmoulin quibbled and tried to avoid the question, they both ultimately agreed that is a downward trajectory. Dr. Van Buren talks to you about the tongue. And it's right. Dr. Howard did a good thing when he saved that tongue. He saved something of evidentiary value. And despite his proclamations that he saved lots of tongues, he saved this one, and it allowed Dr. Nahr to examine it. And when she examined it, what did she find? She found soot, because it was a contact wound. She found that there was some hemorrhage in the tongue, but not nearly as much as she would have expected to see. And there were all these vessels that wound path, that bullet path, transected. And Dr. Van Buren told you, had her heart still been beating at the time that all of those blood vessels were transected, it would have been profound and pulsated blood loss. John Howard told you that blood can go in 3 places. It can go into the stomach, if there was no blood in the stomach. It can go into the lungs, if there's no blood in the lungs. Or it can go into the environment. Kendy Howard's heart at a C2 transection would have interrupted the parasympathetic nervous system and the sympathetic nervous system. And as Dr. Van Buren explained to you, as well as other doctors, even Dr. Desmoulin this morning, the heart can continue to beat. Now, Dr. Desmoulin tried to point you to a case study where there was some sort of shutdown of the heart. Yet, when you pushed on that case study, well, that gun, that shot, went up through the soft palate and landed in a different part of the cervical. Dr. Howard told you that when he looked at Kendy's body, without any additional information, it looked like other bodies that he'd seen. I determined that this gun, in the absence of evidence of any other cause of death, was the cause of death. Kendy Howard had been alive when that shot went through her mouth. It would have killed her, 100%. Without someone immediately intubating her and getting her to a hospital, she would have died from that shot. But Dr. Howard did not consider the other evidence. Dr. Howard did not consider everything else that indicated that at the time that shot went through Kendy Howard's mouth, she was already dead. Dr. Desmoulin, as well, he told you that, well, if she was already dead, then she couldn't commit suicide. But he had run through all of these different scenarios that looked at whether or not it was possible that she could have shot herself, assuming she was alive. And so many of them he had to eliminate because it was impossible for the trigger to be pulled due to the strangeness of the wrist, because it was not ergonomic to hold the gun in that fashion. Because the trajectory was wrong. And Dr. Desmoulin, coming to his conclusion that it was biomechanically possible that she could have hypothetically shot herself, did not review the injuries of this case. He did not consider she was already dead. Ladies and gentlemen, you have more information than John Howard had. You have more information than Dr. Desmoulin considered. You have the benefit of all of the information from the scene, from the autopsy, from the 2-year investigation that followed. And all of that leads to the conclusion the defendant staged this to look like suicide. And part of how you know that are all of the inconsistencies that he told law enforcement. That Kendy killed herself over a house she didn't own, that she went upstairs and killed herself without even reaching out to anyone to say, hey, is he right? Can he really force me to split this house? No, according to the defendant, she just went upstairs and did it. He claimed that he gave Kendy a loaded gun, but didn't know one was in the chamber. Well, it's true that he gave Kendy, according to the records, the evidence, that he did give Kendy a gun about 10 years prior. And Wyatt testified that he observed her shoot it once, maybe twice, and that was back when the defendant was still at ISP. So at least 5 years before this. And so Kendy would have had to have possessed a gun that was kept in the safe that she didn't have access to, and she would have chosen that as her method to kill herself. Ben told you that Kendy didn't have any life insurance. Abel Tarpley told you that she didn't. Defendant didn't say anything about blood on his hands, didn't say anything about water on the clothes, even though the bath mat was soaked. Claimed that he did not care if Kendy was having an affair. Ryan said different. But he even went farther than that, ladies and gentlemen. He knew that law enforcement was looking closely at this, and so he created this document here. He gave it to law enforcement along with all her pill bottles. Stan's handwriting. He wrote, Kendy's Prozac prescriptions found for major depression. Well, just looking at the bottles, the Prozac bottles, shows you that they were prescribed for compulsive overeating. Ms. Miller told you it was the lowest dose, that it was strictly to make phentermine work better, and that she would never prescribe Kendy that. Moreover, the only person who thought Kendy needed meds, or who at least repeatedly told Kendy that she needed meds, was the defendant. Kendy didn't think she did. And then there was how Detective Sergeant Lawton asked Dan several times about whether or not he had gunshot residue on his hand. Not because Detective Lawton thought that he would be able to test the defendant's hands, because he knew that was not a valid testament, to see the defendant's reaction. And so the defendant had this story about hopping off some round, changing out some sights, yet that gun didn't show signs of being recently shot, and the sights were standard factory. Ladies and gentlemen, you were asked, in order to find the defendant guilty of first-degree murder, whether or not there was premeditation. Premeditation does not require that you find that the defendant was already thinking about this back on January 29th. Although, the state would argue he probably was. You don't have to find that he was thinking about it when he was down in Lucille. Though the state would argue that he probably was. Premeditation only requires that it was reflected upon before the decision was made. You could have made that decision that night, during whatever conversation they had. Now, if you find there was not premeditation, then you should and can still consider whether or not it would be murder in the second degree without that premeditation. And in this case, ladies and gentlemen, the state would argue there is significant evidence of premeditation in part of the defendant. The state has argued to you that a big part of why the defendant murdered Kendy was money. We know from their messages that money was something the defendant cared about. And after Kendy's death, well, the defendant acted in accordance with that same motivation. That hot tub that she purchased, well, within days of her death, he was contacting the seller, getting a deposit back, getting that refund. He contacted Bank of America and called fraud on her legitimate charges that she made in life. That was also not ultimately found to be true fraud charges. Courtney Lampert offered the defendant $2,000 for Kendy's special last chicken collection. But no, on her birthday, the defendant sold Kendy's possessions in the yard to strangers. And when Brooke showed up to try and get some of her mother's possessions, she was battered by her brother and trespassed by her father. She walked away with nothing. Question, ladies and gentlemen, is whether or not Dan could have staged the scene. Could he have shot Kendy through the mouth to throw off investigators, to throw off Dr. Howard? Could he have made this murder look like a suicide? He told Dean Lambert he could. He bragged about it at a barbecue. Dan Howard, an ex-Marine, was trained in that carotid restraint. He knew the dangers of that hold, the lethality of it. He had worked in law enforcement for a very long time, not just as a trooper, although troopers go to many fatal scenes, but beyond that, in SWAT, firearms instructor, offensive tactics instructor, and with knowledge of DNA, fingerprints, ballistics. Dan Howard was capable of making this murder look like suicide at first glance. The more you look at this evidence, the more it leads you to the truth. Beginning of this case, my co-counsel, Mr. Mortensen, told you that there are 5 manners of death: natural, accident, suicide, homicide, and undetermined. Kendy Howard did not die of natural causes. Kendy Howard's death was not an accident. Ladies and gentlemen, the state has shown you, both in terms of who Kendy Howard was, and her passion for life, her plans for the future, and her engagement with her friends and her family, this was not suicide. And the state showed you this was not suicide because a dead person cannot shoot themselves in the mouth. Because Kendy Howard did not commit suicide, this case is not undetermined. Thank you.
Thank you, Mr. Ostwald. Mr. Chair, we're going to take 5 minutes, quick recess, just for humanitarian reasons. I would prefer to finish all the closings. The defense has closed still to go, statements and rebuttal close at the end. If any of you cannot stay after 5 o'clock today to at least get us all the way through closings, please tell my bailiff. I can't keep you after 5 by rule, but if you can all stay, I prefer to finish closings today. bring you back and start deliberations tomorrow. If you can't do that, let my bailiff know. Otherwise, I'll assume that we can get this part at least wrapped up today. Okay? All right, we'll take 5 minutes. know I said 5 minutes, but I asked the mayor to make sure all the jury can be stopped or whatever. So we have a little bit longer. Let's bring the jury in. You can be seated, thank you. Mr. Johnson, you might need your closing argument.
Thank you. Good afternoon, ladies and gentlemen. We talked in jury selection about how to say this twice, and so before I get into my pre-prepared statement, I just want to address a couple things. First is the possible hazard. I know they use that for both their opening and their closing, but it is not impossible for a person to commit suicide. Our common life experience will probably show us that suicide can be surprising, or to make a rational decision. Additionally, testing and science is a way to eliminate possibilities. And so the impossible hasn't been eliminated, but also the bruising has been misleading in this case. And so when you take the exhibits, you'll get all the exhibits back. And I'm purposely not going to go through photos in closing. We'll talk about some aspects and some things that you should look for. But you got to look at one of the timestamps when those pictures were taken. There's a drastic difference. For instance, in the Deputy Wheeler's photographs that were taken before midnight, involved in the tub, and pictures where there's drastic water depth and the line is here. You see the water's clear as they're draining. They're taking photos when they're draining. So they're grouped together. You have 16A through whatever. They're all grouped together. But pay attention to the photos and where that blood line is. As the tub drains, in Northrop's photos in particular, you'll see the blood line. But the bruising is misleading for many ways. And the main thing is, for instance, Ms. Acevedo, her photos are post-autopsy. And again, I don't want to even demonstrate it, but you've seen the pictures. You're basically removing the scalp. You're flipping over the body. You're doing a neck dissection. That's a long period of time. Both Dr. Spock, the first time he testified, and Dr. Howard talked about lividity and where's that blood going when there's no circulation. It's going to raise into some discoloration that looks like bruising and is lividity. So it's careful that you need to do it. But the issue comes down to blood. And the reason why is because there's no petechiae, there's no damage to the hyoid bone. And Dr. Smock's explanation is that if you do this restraint a particular way, you can cut off 100% of circulation, and that's why you would see petechiae. Obviously, if we stop petechiae, that changes the whole case. So the case does come down to the volume of blood on this. So first, obviously, in all of our experiences, we have tragedy. We respond to tragedy in different ways. There's different people that will respond very emotionally, other people are more stoic. But I walk towards tragedy. And I want to be clear that just because we're defense here, this is a tragedy. No matter how this pans out. Whether she committed suicide or not, that's for you to decide. But it's a tragedy either way when we're dealing with a case like this. But the point of talking about that is when you were selected as jurors, you're making a commitment to set aside the emotions. These are very emotional. We hear stories from family. We hear stories of situations. It's very, very understandable to feel the loss of Kendy. But you as jurors have the toughest job to be able to separate those emotions. Talking about emotions is people respond differently. We've heard Dan described as stoic and reserved. We've heard him, we saw his son, Wyatt, on the stand, who comes across maybe stoic and reserved, not painting testimony, but basically being open when asked by counsel, would you change your opinion if you saw X, Y, and Z? And says yes. Compare that to a sister who very clearly early on, first phone call or when she calls back, very emotional. People respond differently. And so it's important that you take the emotions into consideration, but focus on this case objectively based upon the facts that you have in front of you. There very clearly was a family dispute, and that's evident, and in some ways that may have shaped this case. But we talked about the different personalities. So I want to walk through some of this. The 7/10 incident in 2020. You have video that shows officers responding and there's no abuse. You also have a 911 call. It's up to you to determine the credibility of the witnesses and what your observations are, but her state of mind when she makes that call. But she very clearly tells the officer there was no physical abuse. The only comments are to Michelle and to Mr. Prado. Now what's significant about there is throughout this, we have to examine her credibility in the sense of contextually what was going on. She told Mr. Prado that Dan made her delete all the photos. Well, clearly that didn't happen because the photos were there almost a year later when his phone was seized at the scene, or when her phone was seized at the scene. The photos were there, you have all the photos and evidence. So she's clearly not being honest with her conversation with Mr. Prado. There are witnesses, Carrie and Brett, and you can examine their credibility. You know, the state wants to say, well, they could have gone to law enforcement at any time. Well, why would they? We're talking about someone falling against a boat. You wouldn't expect to go to law enforcement with that. You only go to law enforcement if you expected something illegal happening. So why would they go? It wasn't made aware to them until 2023, was testimony of Detective Lowell. And 27, 28 years, not a single person has said, that even that Dan raised his voice in anger. We have reference from Brooke that there's some name calling as far as weight and stuff. No witnesses to any abuse in almost 30 years. No witness to any physical abuse of that sort. So it makes you wonder. Why do we have the search? A bruise on your chest that was not investigated. The date of that is 10 months prior. There's no witnesses, and there's really no admission from Kendy that Dan affirmatively did it. So why did they charge him? You know, that's maybe relevant, maybe not, but maybe it's to bolster the case. So your instructions, you can do it how you want, but I would advise you to read the instructions, particularly the ones that we went over 2 weeks ago. You each get them. This is kind of like a Bible. So when we walk in here, there's not going to be a lot of dispute. We're not, the July 20th day Bible, but the issue is whether he actually. There's a delay or something. Okay, there it is. The one thing I would say about the date is the date is not about the bruising, lividity, contusions, discoloration from her death, autopsy, etc. The bruising is as it relates to the incident in July 10th. Now, you'll have the photos, you have photos of the trailer, you have the testimony, and you'll be able to look at the bruises. And you can see there's a big bruise that kind of trails off to the center, consistent with petroleum. So you can examine it. But I don't want to spend much time on the 710 because I want to get into the main issue. It's key to keep in mind that Kendy was living a secret life. And there's no judge, it's not illegal, there's nothing illegal about that, that she was living a secret life. So she wasn't being honest with Michelle, with her parents, or with her husband. She wasn't, and even in some cases, with Mr. Prado. But you have an incident where Dan had come home, you have the messages, you can read through them. There was a delay by 2 days, or suspicion, or you have an affair. You see more of that conversation on the first, where Kendy is accusing Dan of having an affair. Who did you go see? Well, I called the hotel, where you're at. But Dan comes home. There's no black clothes in evidence. When you watch the video, it's a little bit smudged, but when you watch the video, you can see that it's the same clothes that were in the washer. Mr. Prado had a 15-second phone call with her, and they didn't call back. They called her parents and didn't call back. Didn't do anything about it. So, there's no dark clothes found anywhere in the house. There's no gloves in evidence. There's no anything. So she comes home the next day. And here's again, some of what we need to take the emotion off and focus on the science is there's a balance in a 28-year relationship of, yeah, I want you back. Hey, I love you more than anything. Please come home. To being controlled. But she does come home, and they spend the weekend together. And here's where I think it's interesting to read some of the messages to Michelle, Tana, and Mom. She's talking about how calm they're going through their divorce, that they're splitting the assets even. Here's that, and they even text photos. She even texts photos to her friends. Now, so that 129 event, we don't know what was going on. It doesn't, if you were to believe that someone is standing in black clothing that didn't have gloves with firearm, then yeah, it's concerning. But that's not what the officers found, and that's not what you have before you. That's a statement that she made to her family after she left. She packed a bag, she left, she came back on 31st. So can she be suicidal? Well, I would posit that the family is probably not the people you should talk to. Either side, either the son or the daughter, because it is too close to home. We don't want to think that a loved one has committed suicide. But let's look at Dr. Hanger. Dr. Hanger conducted an evaluation and elicited factors, and he talked about the home's Roy Life Stress Inventory, and he found that she had a moderate to high degree of experiencing difficulty coping. Now, he made adjustments to that, but the adjustments were made based upon early statements from the family given to law enforcement close in time to her passing. There was no direct examination of Kendy, obviously, which can increase the confidence level. And he specifically, he took me over the corner on his report, and he finally admitted in the report that it is not possible to provide an absolute predictive determination of suicidality from a record sheet. The point of this is, let's look at the science, let's look at the scene, let's look at the evidence. It's not let the emotions and the could she have done it, or would she have, we probably all know people that we never would have expected that make rash decisions. We got to think about the science. So, here's some of the factors that I think are in favor of that. She described herself as being in a midlife crisis more than once in the evidence that you have with text messages. To Roy Finney, part of that is it normal to feel sick to your stomach? This is just on the 31st. Sick to your stomach about the choices you're making. She's, on the first, she's accusing Dan of having an affair, and that's why she's late. She also, that's the same day her affair comes out, and when you read the messages between Dan and Kendy, and also Mr. Prado and Kendy, you'll see, and Kendy and her brother, you'll see, this was just not a small argument. She was irate. She rapped a text to her brother, she rapped a text Dan. This was very, very stressful for her. That her secret life, who she thought she had kept secret, maybe her plan was to get a divorce and then slowly integrate Mr. Prado into the equation. Her plan was not to have the affair come out to her family and friends and have that be the reason why she's getting a divorce. In fact, there's messages that you have where she's told by her friends that you should not be having an affair. If you are, you shouldn't be doing that. She was blocked by her brother on that day. No one can stand here and tell you what she was thinking or what was going on in her head. What we do know is the last message she sent was to Canada.
Objection, facts not in evidence.
It is exhibit defense. Her last message sent was to Tina, and that message talked about her brother blocking her. So let's look at it. Let's separate the emotions. Let's separate hypothetically what was going. We can't know what was going on in her mind. We can feel sorry for the tragedy and miss her. But let's look at the facts and the evidence in this case of a murder or a staged suicide. So first, regarding asphyxiation. The only evidence is a lack of blood. Again, remember that Dr. Schmock compared the carotid restraint, which is taught by law enforcement, to a rear naked choke that was what you see in MMA. In fact, one of the exhibits you have from Polison is 3 pictures that show different holes. One of those is a rear naked choke, and Dr. Schmock talked about the rear naked choke. The reason that's necessary is because you have to have 100% circulation cut off. If blood escapes to the head, you're going to get the petechia. All the doctors agree that there's no petechia. So they're going by, there's not enough blood for it to be suicide. No petechia, no damage to the high volume. So Dr. Howard was the only one to examine the body fresh. It was within 12 hours of the passing that he examined the body. And he ruled death by gunshot. He testified that there's been hundreds of intraoral gunshot wounds that he examined, and the blood that he saw was consistent with the amount of blood that he would find. Dr. Rambaran talked about how, who's a trauma surgeon, not a medical examiner or forensic pathologist, talked about in the volume of blood that you expect. And he used around 800 milliliters to a liter of blood. And he tried to do a demonstration. I don't think it really worked because it kind of just got him on the spot. But he tried to show a demonstration of what the blood would look like. Well, what they did not consider, what no one has talked about, is the amount of blood in the body bag. And why is that significant? They're saying, look at the water. It should be dark from a photo as they're draining it 8 hours later. The reason you have to consider the blood in the body bag is there's only 2 sources of bleeding. The tongue, which we'll talk about in a bit, the tongue, and the damage caused internally to the C2 and its jaw and surrounding areas. So if you consider the blood in the body bag over there, is that enough blood consistent with suicide? If you consider the amount of blood in the body bag, plus the amount in the photos at the beginning when Wheeler first showed up, plus any amount that drained, you do have photos and evidence that showed tough drainage when they did drain. There's a line of blood that has been going down the center to the drain. This asphyxiation, there's like too much blood. They haven't given an explanation where that blood went. And so you have to consider what's in the bag and what's went down the drain. Now, location. There is no theory as to where asphyxiation would have occurred. Did it happen before the tub was filled up? And was it in the tub? There's no blood anywhere found in the house. You heard testimony that they checked into his luminol. There's no blood found anywhere else in the house. And you'll see it's in evidence, a little envelope, about this big. I think there's one rock associated with it too. I don't know if it's tooth rock, it's not glass, but there's and there's earring backing, something, whatever it is, and then a few shards of glass that are about this big that they found 2 weeks later. There's no defensive wounds on Dan. So the one thing to keep in mind is the carotid restraint or rear naked choke is a violent maneuver. She didn't have any alcohol in her system. She didn't have any drugs except for caffeine in her system. She was not overly intoxicated. It's a violent maneuver. She just had her fingernails done. There's no damage to the fingernails. There's no defensive wounds to Dan. So if you look back at the interview, Detective Euler's body camera, he's the one that we had large chunks where we were watching at home after detectives arrived, and they're talking to Dan. And there's a point where Dan, close to 6, it's close to when he made phone calls, but there's a point in time where Detective Loughton goes up and gets the charger. And you see his body camera, you see him go up the stairs, and you see him turn, and you see him go between the bed and the dresser. That's where that glass was. And you don't see it in the video, but 2 weeks later, that's where the glass was, in that area. There's no blood or DNA on the glass. There's no sign of struggle anywhere else in the house. Nothing is found in the vacuum bag. So if that glass had come from a struggle, number one, if he's smart enough to stage a scene, would Dan pick up pieces of glass 2 weeks later? But two, there's nothing in the vacuum bag of evidentiary value, which by itself has evidentiary value. It shows that there was not an active cleanup of the vacuum. Talk about the corner photos. Again, we have this chart. I think it's 19B, this white background with the skeleton, with the outline of the person with diagrams of bruises, right? A lot of those were taken on the 5th in the morgue. After autopsy, after embalming, a couple of days later, what that does not mean, or they have not proven what's lividity versus what's bruising and what's trauma from the process of the autopsy. So, the corner photos were taken on the 5th, after the traumatic experience. You see the swollen face? That's not from injury, from abuse. That's from the autopsy, basically almost removing the face. You have, I showed you one earlier today, you have those photos. But the face obviously is swollen by putting everything back together. They talk about they remove the internal organs. They do a wide incision, remove the internal organs, look at them, test them, put them back. Right? It's traumatic. So looking at the photos from the 5th is a little bit, it could be disingenuous. Both Dr. Howard, we talked about this, both Dr. Howard and Dr. Schmott talked about what lividity is. And Dr. Howard examined the body, no sign of conviction there. What I keep in mind also is in the photos, particularly Wheeler's photos, but you see her resting place in the tub. Her head is slumped down, on her chest. And again, where does blood flow? It doesn't flow. Where does it go? It settles. So what is lividity versus what is bruising? I think the photos there, you can draw your conclusions based upon the evidence. Let's look at the scene. The scene is consistent with suicide. The gun position is consistent with suicide. Now, there's testimony that Dan was a patrol officer. There's no evidence that he worked as a detective, no evidence that he had any sort of homicide training, no evidence of the knowledge of staging a scene that would fit the biomechanical information. When you look at all the possibilities, we'll come back to this, but when you look at all the possibilities, his purpose was to rule out suicide. And out of many scenarios Dr. Desmond came up with, 2 are potentially consistent, depending on whether this is a slide by or not. That takes a lot of knowledge. He has a PhD in biomechanical engineering and is able to examine scenes. For a person not even trained to be a detective, to know exactly where to put the gun, which way to face it, that would fit the biomechanical recreation is a lot of specialty knowledge that has not been shown that Dan has. Dan's DNA is not on the gun, and it's not that he wiped it, because Kendy's DNA is on the gun, and some other male's DNA is on the gun. So that's not just wiping. That would be wiping and placing someone else's other DNA, and that's again, there's no training experience that Dan has had that. Again, scene continued. It's consistent with the slide bite on the thumb, but as you heard Dr. Desmond, even if you think that's not a slide bite, the possibilities go up. There's more scenarios that are consistent with suicide. Dan's DNA wasn't even on the bullets of the magazine. Now, let's talk about that for a second. When examining his credibility, Kendy told Mr. Prado that she was excited. She was getting her guns. She was getting her guns. So, from her own words to Mr. Prado, she was excited about having the guns. It's splattered, and many people testified about the splatter to the left hand, to the right hand, to the nipple. And so, again, how do you stage that, especially without training? When you look at the photos, particularly again, earlier one, you will see on either side of the neck dark pools of blood that are going down. And when you compare that to what you observed from testing the blood and how it interacts with the water, the state has not accounted for the blood that has been spent in the scene. The blood, this is, I think, 18A, but the hair, the first picture of the body, when you look at that, you'll see the hair is absolutely matted with blood, caked on the body and all that. Now let's talk about the tongue. Dr. Howard said, point of injury, rare to have it hit the tip. Tongue is a muscle. Muscles go to rock state upon death. Now, you heard me ask that a couple of witnesses. But here's the point. The injury is to the tip. If you are alive, or if you are not alive, what is the natural resting position of the tongue? Behind front teeth. Behind front teeth. So if she was not alive, how did the top of the tongue get injured without damage to the bottom teeth? That injury of the tongue is consistent with someone who was alive at the time of gunshot. Talk about gunshot residue, and none of the witnesses put a lot of emphasis on gunshot residue, but I think it's important to ask a couple things. During the video of the encounter between detectives and Dan, he was asked on, I think, more than one occasion, if you wanted to do GSR. He immediately says, yeah, you can do it now. Detective Northrup, I went through all the details. He's talking about how, what the weather is, what kind of house it is, the amount of detail that he put in his report, so much detail. Yet, in his report, and he admitted on stand, he did not put that Dan did this. That's never in any of the reports. They didn't take his clothing. If they thought that he did that, why wouldn't they take his clothing? But is it something that was added later over 2 years later, now when it goes to grand jury? They didn't send Dan's kit to the lab. You have a picture of the kit that Chet talked about today. The kit that went to the lab was from the autopsy, and you have that in front of you. Let's talk about the arm. Burn, not burn. So let's look. If it's a burn, again, it's not cause of death. It's not related to the gunshot, and it's not a defensive one. You put your hands up, right, onto the back of your arms. Where's the injury? It's on the inside portion of your arm. That's not offensive. But it's also, there's no other evidence or moisture as far as wherever it would have occurred, that some liquid was thrown. There's no evidence of that anywhere. But could it be from making tea on a blazing hot, as was described, scorching hot basement thermos or kettle that's on the stove? Yes. But it's not related to the death. So is it a burn? That's not what the case hangs on. And even if it is a burn, there's no cause, there's no theory that Dan created that burn, there's no offer of proof that Dan created that burn. There's just, here's a burn, he must have done it, let's use this against him in that trial. But Dr. Howard, who again was the only one who examined the body while it was fresh, described that as skin slippage. So he talked about how when you're submerged and you're under pressure, the skin slippage or the decomposition basically is rapid. Look at how she is in the tub, particularly, again, in Detective Wheeler's photo. Her head, her arm on the left side is up. Her body is a little bit leaning to the right. And her arm right here is up against the tub. Is that consistent with skin slippage? But either way, it doesn't, the case is not hinged on that injury, but I think it's important to point out why Dr. Howard, who's never testified for the defense in his career as the main witness, believes that it was skin slippage. Bruising versus liberty. We talked about this, so I'll just. The only other thing I would tell you, Dr. Howard's opinion was death by gunshot. You have a piece of evidence in you. I believe it's Defense Exhibit C or D. I think it's C. That Asa Beto, she took the photos on the 5th, February 5th. She agreed that she wouldn't sign something that she didn't agree with. She issued a death certificate. You have an evidence with her signature on it from June, saying that the cause of death was transection of the C2 with a penetrating gunshot wound to the head and neck. That was her opinion. Obviously, now it might be changed, but what you have in there is the photos and the video. Let's talk about Dr. Smunk. First, he was asked in 2001, and he said he needed more information. Right? He saw the bruises or the marks, or the vid, whatever we want, contusions, whatever, blunt force trauma, whatever word we want to use, whether it's blunt force trauma like this or whatever. He saw the photos from the coroner. He saw everything back in 2021. When he issued his opinion, you heard the first time he testified, it was after Dr. Dozen issued his opinion in October of last year. Everyone else is wrong. Dr. Nard is wrong that the blood can be contained in the mouth. Dr. Nard is wrong that the lips and the broken jaw are consistent with a gunshot trauma, interval gunshot wound. Dr. Lambert is wrong that the lips and the damage is consistent with a gunshot wound. Dr. Howard's wrong that the lips and the jaw were caused by a gunshot wound. Everyone else is wrong except for Dr. Swan. The blast and the trauma of the blast, whether that's bruising or whatever that is on the scalp, that caused from hitting the head, there's force involved with the explosion of a firearm. Someone sitting in the tub, head's going to hit back. Additionally, when it does, there's going to be some damage to the head and mouth. Dr. Smock said, or asked or said, he was 100% convinced. I'm not much in science. I mean, I love science. I'm just not very good at it. But 100% doesn't seem very scientific. That seems convenient. Compare that to Dr. Desmond. He set out to rule out suicide. Rule out suicide. This position, not suicide. This position, not suicide. He said, and what is his opinion? His opinion isn't sitting here before you, bolstering himself, saying, yeah, I have an opinion that she committed suicide. His opinion was, the evidence is consistent with suicide. That's for you guys to decide. Dr. Swan, 100%. 100%, this is my opinion. Everyone else is wrong. With that. We already talked about how that one exhibit includes the post-autopsy photos. And Dr. Spock did not do any testing or modeling or putting together a theory of what actually could have or would have happened. We heard Dr. Desmond say testing is worth 1,000 experts, and we kind of see that in this case. We'll come back to that. So examining Kendy's own statements, there was secret affairs. She was upset about the house. She was actually excited about her gun, back and forth on what she wanted to do. Didn't have a job lined up. Here's the thing, grass is always greener. But she didn't have an exciting future lined up. Pieces weren't together. She didn't have a job. She didn't, there were issues with the house, and she didn't even know if she wanted to leave Dan or not. And we talked about it last. Her last message was not to Dan Prado. Her last message was to Karen, regarding her brother. Looking at Dan's statements, the house was added to the paperwork. You can check that for yourself. February, the heater's running. We had testimony that it was blazing hot in there. Testimony's going. How do you hear water from upstairs? If you're in the basement, how do you hear water from upstairs? You hear it through the walls, through the pipes. You hear the pipes, the water. How do you know someone flushed the toilet upstairs? You hear it through the walls, right? So yeah, he hears the water, but the fan's going, washer's going, or not the washer, the dryer's going, and he hears something like a thud. Yeah, little things matter. If Dan has set a scene, why would he say that he heard a thud? Why would he say I heard a gunshot, went upstairs and called 911? Right? He's former law enforcement, former firearms instructor. If he was setting a scene, why would he say it was a thug? He was cooperative with law enforcement for hours. And we heard, I think during opening, we heard that you would hear testimony that was asking people for coffee or whatever. To watch, 4 or 5 hours of video, not once did he do that. Most of the time he sat in the same position, And again, people respond to emotional trauma differently. How he responds might be different from how another person responds, which will be different than how another person responds. But what did he do? He cooperated with law enforcement. He made mention of a prior incident where Kendy had expressed suicide ideation. Put a gun to her head, in the bedroom, in the closet, pulled it down, and when she pulled it down, she discharged. The officers went to confirm it. They found a hole right where they said it was. Why? Well, again, it was objective, not emotional. Said, yeah, when I was in middle school, a bullet came down. We didn't get into hearsay. That's what he observed. A bullet coming down through that closet floor. We'll talk about the 40 gun. There's photos and evidence. You go through there. You'll see Fallon. You'll see the breach. Also, what you'll see if you examine it, you also have the physical 40 itself. You'll notice that the sight is all the way to the right. It's not in the middle. And it's, again, it's talking about how he changed the sight. He moved that sight all the way to the right. You'll be able to examine that. So examining the totality of the scene. Blood sinks to the bottom when agitated. Dr. Desmond did force scenarios. There's no way to quantify how much blood was drained. And suicide is consistent with the evidence. We see the blood line around the body. Again, when you examine, you might find that there was more there appears to be more than 800 milliliters that Dr. Rambert said he would expect to find in an injury. The scene, the blood, the body bag, drain, the tub, supports that there was a lot of blood. And again, the state doesn't have any evidence of how the scene was staged. And I apologize. I see what there is a delay in this. No theory. Was she placed in the tub, then water filled up, then shot? Why isn't there more water around? The only part of water is there's a damp in the bathhouse. It's not on the floors, nothing. If the water's in there, then Dan certainly would have blood on him. And again, it doesn't explain there were no gloves found, so he would have had to use his hand and scrub it and put someone else's DNA on it. So the state hasn't offered one theory on what happened. Where the asphyxiation took place, when she was shot, why there's no blood anywhere else in the house, and no evidence on Dan, no scratch marks, a person who's not intoxicated, not drunk, is not going to let someone just sit, is not going to sit there and not attack, especially with fresh hands. So we looked at, I just have a couple more slides left. We looked at the Dr. Desmond's chart, and the point of this chart is they considered more than 10, but they ruled something out quickly. If it was a left-handed fire, would have been to the left side. So rule out those. And you go through here. There's 2 that are consistent. If we remove the slide light, there's 2 that are consistent all the way across the board. With the slide light, if that is a slide light, then there's one scenario that's significant. The point of me telling you that or pointing that out is how the technical expertise it would take to stage this scene. It's not just choking her out, shooting her, dropping the gun in the tub, watching her hands be done. You actually have to place the gun a certain way. You actually have to get everything just right. And you have a lot. I'll continue without that. So we saw on here the blood accumulation in the water, and you remember the test that remember the test that we had. The blood accumulated in the water. The blood testing in the water. When we saw that, how the water or the blood sank to the bottom. It didn't just make it. It's not a toilet where you have a bunch of movement and agitated water as you're turning it. The water shows that it was draining. The blood pulled to the bottom and went from there. So when we get to this, I'm just going to fast forward this portion. When we get to this portion, you all remember the testing that was done, and it's so significant because this case is about blood. The testing of the blood and the line that goes, and what the hair does. As the water drains, the hair is not going to be as noticeable or visible in later photos, and how the blood was traveling. You see that. When it's all said and done, there is no theory. It doesn't fit the science. It doesn't fit the scene. It does not fit the facts. When you separate out the emotions and look at the evidence, the scene is not disturbed. And that burden is a high burden. Many of us have friends and family or ourselves that have served in the military, protecting our Constitution. Being presumed innocent on every count until that presumption is overcome beyond a reasonable doubt is one of the fundamental principles of what we fight for the Constitution. And that burden, when applied to this case, is significant. You don't have to put your stamp of approval on Dan. You don't have to like him as a father. You don't have to like him as a husband. He's not on trial for that. He's on trial for domestic battery, from a bruise, and for first-degree murder, for a staged suicide. That doesn't fit the evidence. Even if you believe it's more likely than not, then you have an obligation to find him not guilty, because that's not the same standard. Ladies and gentlemen, when you apply that to this case, you have to find him not guilty.
Thank you, Mr. Johnson. Word, Ms. Oswald?
Thank you, Your Honor. Ladies and gentlemen, at the start of the instructions, the judge told you that the arguments of attorneys are not evidence. Because Mr. Johnson can argue that this is defensive posture. The state can argue that this is a defensive posture. Someone throw hot water in their direction. Ladies and gentlemen, Mr. Johnson told you a lot of facts, and you get to go back, you get to review the facts, you have your own notes and your own memories, and you get to decide what the facts are. What you remember, what you heard, and you get to apply those to the law. Mr. Johnson, he was right about one thing. He was right that the state cannot give you a blow-by-blow of what happened that night. There are two people that know what happened that night, Kendy Howard and Dan Howard. Did she get that burn first, or did she step on the glass first? Was she grabbed on the upper shoulder first, or did she get that bruise across the back of the thigh? The state cannot answer those questions for you. What you have to do in this case is decide whether or not Dan Howard murdered Kendy Howard by asphyxiating her with malice and premeditation. You have to make that determination beyond reasonable doubt. The state being unable to tell you the exact sequence of events is not reasonable doubt. And there's an instruction on reasonable doubt. I'll read it to you and you'll have it back there. And it is not the shadow of all doubt. It is not a witness saying, I ran many scenarios and it is possible that this happened. The state does not have to eliminate every possibility. Is it reasonable to think that Kendy Howard committed suicide? No, it is not. The state has shown you beyond a reasonable doubt that the cause of Kendy Howard's death was the defendant. Let me ask you to do. Thank you.
Thank you, Ms. Shopstall. Members of the jury, I'm going to excuse you for the day. It's 5:30, and my intention is to excuse you, have you back here at 9 in the morning. We will select at random the alternate. We'll provide you with all the exhibits, and I'll swear in the bailiff and have you begin your deliberations. Okay, so I think it probably makes sense to proceed in that fashion. So I'll release you with the thanks of the court. I'll remind you not to discuss the case among yourselves or with anyone else, and I'll look forward to seeing you back in the morning at 9. Thank you. Please rise. Counsel, I'm thinking perhaps can you all be back at 8:30 tomorrow? We'll just do a quick confirmation with the clerk regarding exhibits. I trust the state has some ability to provide for watching of videos for the jurors. Is that right?
Yes, Your Honor.
Okay. So let's just make sure. What we need at 8:30 tomorrow, make sure we have that all set to go. And then just as a final word, I want to commend Counsel for the State, Counsel Mr. Howard for the professionalism and good job you have for your clients in this case. All right, we'll be in recess. Look forward to seeing you all later.
All right.
You say I make you nervous, a tragedy. I'm a beautiful disaster, a record.